Welcome everybody this morning to this regularly scheduled board meeting. I ask if you have any electronic devices, cell phones, etc., if you will silence them or turn them off. I'm going to ask Miss Sarah if she will do the invocation and the pledge.
Dear Heavenly Father, we thank you for this, the most holiest of seasons. We pray that the love of God will be shown through us, and we will be reborn and renewed and live and have love inside our heart for all peoples. We ask that you bless every family represented here. We thank you for those that serve us every day, both here and overseas, and we ask that you give them a special blessing. For all these things we ask in thy name. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you. Okay, we have a couple of additions to the agenda. Entertain a motion to accept them.
So moved.
And a motion is second. All in favor say aye.
Aye.
Need a motion to approve the agenda.
So moved.
Second.
Motion and a second. All in favor say aye.
Aye.
Motion carries. The consent agenda.
So moved.
Motion to approve.
Second.
Got a motion and a second. All in favor say aye.
Aye.
Motion carries. Commissioner Pridgeon, I believe you got a couple of presentations. Oh, I'm sorry. Excuse me. Is there any public comments at this time concerning any agenda item? Come forward, please. State your name for the record. Kevin, did you have something? I'm sorry. Okay. I was sitting in behind you. I'm sorry. All right.
Just tell them to turn
it up. Okay. Seeing none, let's move on. Commissioner Pridgeon, I think you had a couple of presentations to make.
In recognition of the Paxton Lady Cats basketball team, I would like for the coach, if he's here today, Coach Williams, anyone you brought with you, or do you have Miss Tucker? Is she here, the principal?
No, she got called out of town.
Okay. Come up, Coach Bradley. Miss Anderson, would you like to come up? Anyone else? Okay. This is a resolution 2014-42. It says, whereas the Paxton Lady Cats basketball team has 5 state championship titles, including 1986, 1994, 1996, 1997, and 2014. Whereas the Paxton Lady Cats has had 30 straight winning seasons, 6 Final Fours, and 10 district championships. And whereas the Lady Cats advanced to the 2014 state championship game, competed against the Chipley Lady Tigers, and whereas on February the 20th, 2014, the Paxton Lady Cats defeated the Chipley Lady Tigers in the final 39-34. Whereas the Walton County Board of Commissioners wishes to recognize the 2014 Paxton Lady Cats basketball team for winning the state championship game, and whereas the Paxton Lady Cats basketball team members include Cassidy Brazil, Lenora Dixon, Sydney Beck, Courtney McKee, Katie Sebastian, Bethany Neal, Emily Murray, Quinn Williams, Allison Carnley, Annie Miles, Peyton Malloy, Kristen Corbin, Genesis Long, and Faith Elmore. And whereas the Paxton Lady Cats were led by Coach Steve Williams, Assistant Coach Randy Infinger, Kim Corbett, Laura Gilbert, and statistician Connor Williams. Now, therefore, it be resolved that the Board of County Commissioners, Walton County, Florida, does hereby congratulate the 2014 Paxton Lady Cats basketball team and coaching staff for their greatest accomplishments in winning the state championship game. Duly adopted this 22nd day of April 2014. Congratulations. Would you like to make a comment or anything?
I want to thank the County Commission on behalf of Ms. Tucker and Paxton High School and the Lady Cat basketball team for your recognition. It's a great honor. It's been great for our community. It's been a high note and a low note, and we're back on trying to get back on the high to recognize the girls and the hard work they've done, and we appreciate everything that you've recognized us for.
Yes, sir.
All right, thank you.
Appreciate it.
All right, we have one point of order we have to take care of. Need a motion to approve that resolution.
So moved. Second.
Got a motion and a second. All in favor, say aye.
Aye.
Motion carries.
Okay, we'll present that to them. Come on down. Everybody come on down.
All come down.
Commissioner Pridgeon asked if I'd like to make some comments. The only comment I have to say, Commissioners, is thank you for doing this, and they won. What else do we need to say?
Thank you very much. Thank you.
See if you can stay. You can stay down there and do this. Yeah, stay down.
Let me make sure it's not in here. No, it's not.
You can vote down there.
We're gonna do the contract today. And then we'll have the legislative.
At this time, we'd like to invite Mr. and Miss Infinger, Sarah Infinger, and Alex up to the podium, please.
And Randall.
You want to get right here?
Point of order first. I make the motion that we adopt resolution 2014-43.
Second.
Got a motion and a second. All in favor, say aye.
Aye.
Motion
Let's
carries.
get it. You want to come on this
Like
side?
for the Randall and Finger family to come
You
down.
want to come on this side here?
Whereas the Board of County Commissioners of Walton County are aware of and deeply saddened by the recent passing of Mr. Randy Lewis Infinger, Jr. And whereas Randy Infinger was the son of Randall and Annette Infinger. And whereas Randy was married almost 25 years to Sarah and had two daughters, Alex and Gillian. And whereas Randy was a lifelong resident of Walton County and graduated from Walton High School in 1982. And whereas Randy began his nearly 25-year tenure at Paxton High School in 1989, serving as physical education coach and then serving in a number of areas such as driver's education instructor, boys basketball coach, boys baseball coach, girls basketball coach, and girls softball coach, winning numerous titles including 4 district basketball championships and most recently Paxton Lady Cats basketball state championship. And whereas Randy served as a deacon at the First Baptist Church of Defuniak Springs for several years, and whereas Randy has always been looked up to in the community because of his generosity, his enthusiasm, his unselfishness, and his concern for the students at Paxton High School and youth in general. And whereas for 25 years, Randy helped mold and shape the character of young men and women that enable them to become good leaders, parents, and citizens. And whereas Randy will be sorely missed in the Walton County community. Now, therefore, be it resolved that the Board of County Commissioners of Walton County does hereby declare April the 22nd, 2014 as Randy Infinger Day. in appreciation for and gratitude for his unselfish commitment to our community, and to honor him and his family for his years of dedication to the children of Walton County, especially the Paxton area. Duly adopted this 22nd day of April, 2014. It is with great honor that I present this to Annette and Randall and their family. And we thank you not only for Randy's service, but for your service, bringing up a young man that was such a good service to our community. We thank you as well. Yeah, you want to, Lewis, you want us? Okay.
Next item is, I'd like to call Mr. Ralph Miller up to the podium. Also the Public Works Director. We're here today to recognize Mr. Miller for his 21 years of service to the county. He's retired April the 30th, 2014. And we'd like to congratulate him on his retirement. And Mr. Stafford, would you like to say anything?
Thank you, Commissioner. On behalf of Public Works, Mr. Miller, and I'm sure I can speak for all the residents on your route, we're going to miss him. Just want you to know how much we love you and appreciate leadership and training you brought to us. You're a good man, no doubt. So.
Well, I just want to say I couldn't ask for nothing no better than the staff that I'd worked under and commissioners, and I've worked under a lot of them. But I can say all about the best I've worked under since I've been out here. And I just want to thank Wilbur and Bob, and the county's come a long way since I've been out here. And I just hope and pray that it goes further, because this county's growing. And you're going to need some good people to work. I'm talking about work. I ain't talking about standing around. I'm talking about working. But no, it's been a pleasure. I would recommend it to anybody. And I know I'm going to miss it. And I'm going to miss the people that we work with. But most of all, I want to thank God for giving me the health and the ability to carry out my job. And that's all I got to say. I just want to say thank you.
We appreciate everything you've done for us and the citizens of this county.
Thank you, Ralph. Okay, Mr. Jones.
Thank you, Mr. Chairman. The first item we're asked the board to consider is a request from Walton County School Board asking us to adopt their resolution 1314-113 that on August 26th primary ballot of the placement of the November 4th ballot in the event of the primary election. That resolution asked that this board place on the August 26th primary ballot a referendum to have the office of the superintendent of schools to be an appointed position by the Walton County School Board. In the event that a primary election is not held in August 2014, the Walton County School Board is requesting placement on the November 4th, 2014 general election ballot. And you have a copy of that resolution in your packet for your consideration. I believe Ms. Anderson is here if you have any questions.
Is there any questions for Ms. Anderson? Seeing none.
Motion to approve.
Got a motion and a second. All in favor, say aye. Aye. Motion carries. That's it. Ms. Anderson? Yes, ma'am.
Mr. Chairman, the next item for your consideration is considering the need for parking facilities in South Walton in the upcoming season. Pardon me. Staff contacted the owner of this parcel that you may recall back in, or may not, in 2007, the county rented through the summer season for parking. As you can see in front of you, it's located directly across from north of Ed Walling Park and to the east of Gulf Place. That parcel is available. Again, I think in 2007 we rented it for about 2.5 months, and the total cost of that was $10,000. We've not had any real discussions about the price, but if the board wishes staff to move forward into some negotiations, we'd be happy to do so. We have had some discussion with Mr. Bagby at the TDC about the possibility of the TDC funding at least a portion of that lease if the board chose to move forward. So with your permission, we would move forward and to have some greater discussions with the owner and bring back a recommendation to you at the next meeting.
Do you want to vote or just direction?
Either
I'll
way
make
is
the
fine.
motion that we go forward.
Okay.
Second.
Got a motion and a second. All in favor, say aye.
Aye.
Motion carries.
Next item is Angie Biddle is here to give us an update on the efforts to find grant monies for the Beaver Lake Dam project. Ms. Biddle.
Good morning. Despite our efforts of looking for funding for this project, we were unable to find any through DEP, Northwest Florida Water Management, or any other state agency.
Well, I'd like to thank Angie for her efforts, but we've gone back out and seen that there's been some action taken somewhere, and even prior to the rainstorm, the lake was filling up really well, and I'm sure after the rainstorm, we've got a pretty full lake. So this may be a moot issue, but Angie, I wanted to thank you and your people for working on looking to see if we could get some grants. But Mr. Chairman, I think that either Mother Nature or the people themselves out there have taken care of the situation.
All right, thank you.
Thank you.
Sounds good. Thank you.
Thank you.
Mr. Chairman, the next item, we have a presentation today from the Florida Department of Transportation regarding State Road 187, the PD&E project overview, and PD&Z. And we will let these ladies and gentlemen introduce themselves.
Good morning, Mr. Chairman and board members. My name is Peggy Kelly. I'm with the Florida Department of Transportation, District 3. I'm here today with Mr. Ryan Witherall from Kimley Horn. Kimley Horn is a sub to Parsons Brinkerhoff. Parsons Brinkerhoff was selected by the district to aid our department with this PD&E study. We're here to introduce the State Road 187, US 331, from I-10 to the Alabama line PD&E study. We will be looking at approximately 48 months for the PD&E study to be concluded. We will be looking at data collection throughout the process to help us better understand the existing conditions and the specific needs for this project area and corridor. We'll be looking at preliminary corridor analysis. We'll also be performing engineering alternatives to meet the needs of the project. We'll be looking at various, one fit will not be the case. We don't believe we'll be looking at everything from passing lanes to possibly capacity where we might have 4 lanes. We'll be looking at intersection improvements where we can assist the FUNIAC with the timing of the lights. Maybe we can bring some type of relief to you through that, and that will not have to be, at the end of the 48 months. We hope we'll have some information that we can provide and help and assist with, some issues that are real small that we can take care of that might bring some relief to you. We'll also be looking at environmental impacts, which are both natural and social. We'll be meeting with the general public this summer. We don't quite have the time set up yet, but we are working on it. We'll also be having a meeting with agencies, federal and state, to get their feedback on this project. Currently, we'll be, of course, asking the public for any comments during our public meeting. Public involvement will be a big issue for us throughout this process because, like I say, it's not one size fits all. We're looking at Defuniak all the way up to the state lines. We're also looking at Paxton, which has a complete different need than what you guys would be needing. We'll have kickoff meetings. Once we have our corridors developed out, we'll hold a meeting. We'll also have an alternatives public meeting. And basically, we'll have on and off unscheduled meetings as needed, and we'd love to hear from anyone in the public, and from you, please. If you have any comments, questions, please don't hesitate to contact us. And Brian, did you have anything you'd like to add?
No, I was just going to say that we've already begun our data collection efforts. We will also be coordinating with the Alabama Department of Transportation as to what's going on in the Florala area also. So we're going to continue that data collection through the 4th of July holiday, and we'll continue to build our understanding of what the needs are along the entire corridor as we go into that corridor evaluation phase.
Good. Any questions?
What do you think the timing of the whole project is?
We hope to have it completed within 48 months if everything goes well. Usually our hardest issues to get through are with the agencies, because there's species, there's habitats, and depending on what we find out there, usually it's the agencies that we have the hardest issue of working through, making sure that, we either avoid or mitigate the process so that they're happy. If we don't make them happy, we don't get to move forward. So we hope 48 months.
And then after the 48 months, what happens?
Once we get through and get to public hearing, we bring all that information in together, then all that, the environmental document, we hope will be an environmental assessment document, will go to Federal Highway for approval. And we anticipate that normally takes 30 to 60 days if we don't have a lot of back and forth with comments from them. Once that's done, we hope within 4.5 years total, we will be done with this and it can move into design.
Okay.
And after design, how long will design take?
Design can take a couple of years.
Couple of years?
Yes.
So we're
yes.
looking 10 years down the road? Turning some dirt?
Yeah, most likely. It depends on sometimes when they hit the design phase, they can get accelerated and move right into design build, and that's when you see things happening a lot quicker. We'll have to have right-of-way, also the construction phase. It would be great if that could be the case. I'm optimistic and hopeful it will happen for you.
Thank you.
Okay?
If we had to guess a year that it would be complete by, what would?
Are we talking asphalt on the ground? 15?
Yeah.
15 easy?
2015?
No.
We're going to say that.
Add another 15 years. Add another 15 years. We're
Okay,
talking, yeah.
15 years from now.
Yes,
Okay.
yes. So we're probably talking 2030, unless it hits the design build phase. I mean, it could, because we just don't know. We never know what projects, when we're in PD&E, will get escalated forward. And if it hits the design build, then it does move faster. So.
I won't be around that long.
One of the
Cindy, so you'll have
challenges
to
I
be
think
there
you're
for
going to
one.
face is going through Paxton. One of the challenges going through Paxton, so proximity to all those businesses right on to 331.
Yeah, that one's
going to be
going to be tough.
And the school and all.
Everything's right on the road, and we don't want to go in and do something that's going to destroy what makes that community what it is. That what everybody loves and they live there for. So we'll have to work closely with the folks in Paxton. We hope we'll get a lot of feedback from them and you as we proceed forward. We hope the public will not be shy. We hope they'll come out to our meetings and tell us what they like and what they dislike.
Do you think they will go around Paxton?
I don't know. Honestly, right now, we don't know. That's why I was saying one size doesn't fit all. If we did a capacity through there, we'd have to really look at restricting the lanes down. We're not sure what we would be looking at this point in time. Our contract just got signed a month and a half ago, so we're in the baby phase right now of the PD&E. We don't really know what we've got yet because we are just getting our data collected. So it's going to be interesting to see what we're going to have, because it's a 25-mile stretch, and we just don't know what we're facing at this point in time.
But it would also depend on where Alabama comes down,
Yes,
connects
sir.
to the.
And we're going to be coordinating with them. We're not just going to come to the Alabama-Florida line and stop.
Yeah.
We're actually going to have to coordinate with them to see where they're coming in with their roadway. And that might, again, have something that would bear down on the Paxton issue. We just don't know at this point, because Parsons and Kimley Horn did have some preliminary discussions in the very beginning with ALDOT, but we have not gotten back to them to see exactly where they're at. I know they were up around the Florella area, but our last word was that they were a little bit further east of Florella, which would play nicely into what we're trying to do if that works out. So.
One thing too, I'd like to put a word in for sidewalks. Desperately need sidewalks on 98, and I know they were in the plan to begin with. They were taken out, I think.
US 98?
On 98, yeah, in the Walton County section.
Oh, you're talking about south? Ours is from I-10 to the Alabama line.
Oh, I know that, but I'm saying that sidewalks on 98 are desperately needed. So when you four-lane these roads and such, sidewalks to me would be desperately needed on this section too. I mean, anything
Okay.
you do.
Yeah, we're looking at pedestrian, from improvements on that, bicycle and sidewalks.
We're seeing now that on 98, I'm just using that as an example,
Yes, ma'am.
that sidewalks would have carried so many people on bicycles and pedestrian since the area's growing. So just when this is designed, I would like to see sidewalks on it.
And we will be looking at that, but we definitely love to have your comments about that too. So we look forward to hearing from you on that.
Okay.
Any other questions? Seeing none? Thank you very much for coming.
Thank you.
Thank you. Mr. Jones?
Mr. Chairman, staff is requesting permission to extend an invitation to all interested insurance companies licensed in the state of Florida to submit proposals for providing group basic life and accidental death and dismemberment, which is a voluntary group term life, employer-paid long-term disability policy, and an employee assistance program for eligible employees and retirees. We've not bid these policies out in some time, so we'd just like the opportunity to do that to be sure we've got the best deal we can get.
Very well. Board's.
Just remind me again, is term life and disability, that is an option for the employees to pay into?
I think it's a little bit of both. I mean, we
it?
have some life insurance on employees, but they can buy more.
Okay. But the disability is definitely something that you have to pay extra into?
Yeah.
Because it's usually pretty expensive.
Yeah.
But anyway, okay,
Right.
thanks.
And we offer all of these now. We just want to make sure we've got the greatest benefit for the money for our citizens and employees.
Okay, we have a motion. We have a second.
Second.
Second. All in favor say aye.
Aye.
Motion carried. Mr. Jones?
Thank you, Mr. Chairman. From Public Works, we're requesting to approve the East Indian Creek Ranch Road from County Road 288 to Bruce Creek and County Highway 185, also known as Leonia Highway, from State Road 83 to the Holmes County line for funding consideration through the Small County Outreach Program, or SCOP, for Public Works. We annually submit applications for projects to the Florida Department of Transportation in order to pursue state funding allocated through this SCOP program. And these are the roads that Public Works recommends that we submit for this year. There's requirements that they be in rural areas and outside of the existing TPO boundaries. And these roads have been vetted to take into account interconnectivity, traffic counts, road conditions, and the other variables that would make them candidates for paving through this program.
Okay.
Motion to approve.
Second.
We had a motion and a second. All in favor say aye.
Aye.
Motion carries.
Thank you, Mr. Chairman. Similar request from County Road 183B and County Road 181A for funding consideration through the Small County Road Assistance Programs known as SCRAP. Again, very similar project, and staff recommends those roads be submitted for SCRAP funding.
Second.
A motion and a second. All in favor, say aye. Aye. Motion carries.
Didn't do nothing.
Mr. Chairman, we have presented you with a flood mitigation policy, including when we would consider pumping areas. We've tried to come up with a policy that's fair and equitable, but primarily designed to protect county assets, and so we recommend your approval. So as we move forward, we will have a firm policy of how we will handle those situations.
Any questions?
Motion to approve.
And a motion and a second. All in favor, say aye. Aye. Motion carries.
Thank you, Mr. Chairman. The next item is regarding appointments to the Design Review Board, the Planning Commission, Zoning Board of Adjustments, and Code Enforcement Board. In your packet, you have included a number of names associated with each of those boards. Some of the terms have recently expired. Some will be expiring soon, if not already. Most of those who are currently serving have indicated their desire to continue serving, and they are, you see those listed in the beginning with Tim Norris and the Design Review Board through the Planning Commission and Zoning Board of Adjustments and the Code Enforcement Board. If there are no change, and I believe Tom Patton was added to that as an at-large member of the Planning Commission, and Mr. Patton wishes to continue as well. So I would suggest, and if Mr. Davis would concur, unless there are changes in those who are currently serving and wish to continue to serve, that we take one motion and adopt them all.
Yes,
if there's some of them are specific appointments to commissioners, so if you want to remove any of those, this would be the time to do that. Or if you would like to recommend any of them to serve at the at-large positions, we could do that as well. So absent wanting to remove any of these from the seats they're currently serving, we'd entertain a motion to reappoint that slate.
So moved.
Second.
I got some discussion, please.
Okay.
All right, there's some of these boards here that wasn't corrected after redistricting, and like Mr. Balee, he shows me in District 1 when he's actually in Miss Meadows' district.
Just Anthony Valley.
Valley, yes.
Yeah.
And
Yeah.
all I wanted to do is just make sure they were properly listed in the district in which they live now that redistricting took place.
Yeah, he's now in District 5, and he said he wanted to be reappointed.
And
so.
we had Mr. Fletcher, right, I knew he did, and
Right.
he's in shows in District 5 originally, and now he's in
Right.
District 1. Still in Freeport, Bill? Okay. So as long as those corrections are made on the list at the time.
So we would flip those.
Yeah.
Bill would be 1, and Valley would be 5.
That's correct.
Okay.
Okay. And if you'll include that in your motion, we'll make that change right now.
Okay. What about the Design Review Board and the Zoning Board of
We're gonna
Adjustment?
deal with-
appointment? We're going to do that
Yes,
separate.
ma'am.
Okay. Sorry.
Okay.
Okay.
We have a motion and a second.
I've got a motion and a second with the amendment.
With the amendment.
All right. Motion and a second. All in favor, say aye.
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 Opposed? Motion carries.
Okay. At the bottom of that list, Commissioners, you see the two parties from the Design Review Board and one from the Zoning Board of Adjustments that do not wish to continue to serve. The ZBA appointment is a District 3 appointment, so we would request Commissioner Empfield to make a recommendation to that board. The other two are at large, and I know that perhaps some of you have some names that you would like to be considered. You can nominate and vote today. You can ask us to make sure those candidates have their volunteer forms and get you further information on each of them before you make that decision. So it's kind of at your discretion, but we would yield to Commissioner Empfield for his District 3 Zoning Board of Adjustments appointee.
Thank you, Mr. Jones. Mr. Chairman, I'd like to nominate Mrs. Tammy Runge from Mossy Head to serve on the Zoning Board of Adjustments.
What was the first name?
Tammy, Tammy.
And how do you spell the last?
Runge.
Is that your motion?
That's my motion.
That's your
I'll
mo-
second.
Got a motion and a second. All in favor, say aye. Aye. Motion carries.
Now, the two appointments for Design Review Board, if you, I'm sure each of you have some names you'd like to consider. If you want to do it now, you can. If you want to submit them to us for applications and stuff, we can move forward how you choose.
I'd like to nominate Lee Moore
I have a question on that.
on the Design Review Board.
Commissioner Meadows?
Yeah, I just have a question on it. When it says affected property owner, does that mean that they have to own property on the scenic corridor,
you help
on
us with that?
98? Do they have to own? Because I know that Greg Griffin does, and I don't know about Russ Tomey, but
I didn't see those.
what is the criteria?
Chair, it's my understanding that you have to be a property owner or own a business on the scenic corridor.
That was
Okay.
my
A property owner or own a business.
Okay, does
But both of those don't want to serve anymore.
right? I know that, but the new appointees need to have a business or a property or own property on 98. So that my question is, I saw the two people that they suggested. My question is, do they meet that criteria?
I know Ms. Moore does. She not only works at a business on 98, she also lives in Inlet Beach on very close to 98.
Very close to 98, but I think you have to have property on 98. Isn't that it, Keith? Wayne?
Chief.
I think you have to have property on 98. And that's just part of the criteria.
And I'd probably look for Mark for a little bit of help on this. I mean, it's as my understanding, you have to own property on 98, and that was owned. Is it near or adjacent? Would that qualify? I'm not sure.
I don't remember it saying adjacent, but I do remember it saying on.
Yeah.
What I would suggest is submit the name and then let us vet it to see if they do.
Okay.
I think that'd be the easiest thing.
Yeah,
Yeah.
'cause I don't remember adjacent, but I do remember on. But I'd have to pull the ordinance. And look at it.
And the design review board are the people who made the rules up. So, this is their, I don't think we did this. I think this is what they put in their thing because they wanted people who lived on, who had, vested interest in 98. So, but anyway, that would be my only comment there.
Okay, what names do we want to submit for them to vet out? Ms. Moore?
We can shoot you an email and get them in the next day or so.
Okay.
Okay.
There were
I don't
two,
think
weren't there? Wasn't there another one?
Yeah.
Besides,
Yeah, there was another one that Howard Group suggested, and I think it was, who was it? Tom Waldrop. Yeah.
Mr. Chairman, I'd received two names, and I forwarded them out to everyone. Tom Waldrop and Lee Moore were the two names that were given, submitted, and I just distributed those out to everyone else.
Yeah,
We'll get an email out to each of you this afternoon requesting those names, and then we will get them to fill out the appropriate applications, and then
see
we
if
can
they're
vet them.
qualified. If not,
Yeah.
then we'll move forward.
Okay.
Okay.
Mr. Chairman, Commissioners, sometime back, we voted to establish a kind of a standby date of the third Tuesday of each month when Planning Commission items tend to run long. At last week's Planning Commission, we had about 2.5 hours worth of projects. It's probably be a good opportunity. A couple of them could be a little bit lengthy at the commission meeting, so we're requesting and suggesting that we utilize that third Tuesday in May to hear those items at a special called meeting.
Mr. Jones, are all of the items required to be heard after 5 o'clock, or are there some that can be heard prior to that time?
We're searching for that answer. And I apologize, you asked me that earlier and I forgot to check.
It's both legislative and quasi-judicial items.
But
So
not all of them are required to be after 5.
It's a bit of a mix. The comp plan amendments have to be heard after 5. I think everything else could be heard before 5.
Well, I tell you, we'll take a look at it, and if we start at 4, we'll do that. If we have some legislative items that we can hear before 4. So,
But we are going to need a motion and a second to set the meeting date.
So moved.
Second.
Got a motion and a second. All in favor, say aye.
Aye.
Aye. Motion carries.
thank you, Mr. Chairman. That's all we have.
Mr. Bagby.
Good morning, Mr. Chairman, Commissioners. First agenda item we have is a request to advertise an RFP to rebuild our website. Website's about 4.5 years old, and we're continually having problems. So we'd ask for a motion to approve that. And we
Motion
anticipate
to approve.
the funding will be, it wasn't in this year's budget, but the funding will be from excess revenues from this year.
All right. Ms. Meadows, was that a motion?
Yeah,
What was
motion to approve. That was a
Second.
mumble motion.
A mumble motion? Okay. I'll mumble a second. How's that? On a second.
Okay, we got a motion. Do we have a second?
She said.
Did
I
she?
mumbled a second.
Okay, we got a motion and a second. All in favor, say aye. Aye. Motion carried.
Second item, Mr. Chairman, is a request to approve and appoint members to North Walton Advisory Committee. The guidelines we've distributed, the comments that we've heard back from the board and from the community is we need to add a appointee from or a representative from Paxton, and to keep an odd number, we'd ask that either you allow the school board to make an appointment or some other entity, Mr. Jones or anything, just so we can keep it odd on the board. And so the only amendment to the guidelines that were presented would be 2 additional seats, one of those being from Paxton and then one being from another entity.
Okay. Any comments, discussion?
Mr. Chairman, I just had one, and I'm sorry, I meant to call Mr. Bagby yesterday and just got busy. Are there terms on here, or are they going to be staggered, or are they going to be all at the same time? Or
I believe the terms are 2-year terms for the chairs, and I think they're going to be 4. They're going to match the commissioners' terms, so every 4 years.
Thank you. Mr. J.B., come forward, please. State your name for the record.
2 years for the chair, 4 for everybody.
I'm J.B. Hillard, resident of Funiac. First of all, I'm not speaking for the city of Funiac. Concerning this proposal, as you know, I've sent you some correspondence requesting a 2-week delay on approving it. I do understand that this was not received by the city until the first part of last week, and it has not. The city has not had a city council meeting to discuss it, and I think it's prudent and reasonable that the city have that opportunity to discuss it with their constituents here in the Funiac. As you know, what is the proposal is a reasonable approach to this issue. It's not something new. TDC has funded activities north of the Bay for the past 12, 14 years, several of them, Christmas Reflections being one of them. So I think as a matter of cooperation and clarity for the citizens of Funiac who were there when the other issues were raised about expanding TDC north of the Bay, that they have an opportunity to discuss it with their city council. And that's all I'm asking for, just a 2-week delay. I'm not opposing it. I think it's a reasonable approach. I'm just asking the courtesy be extended to the citizens of the Funiac to weigh in on this with their city council. Thank you.
Thank you.
Mr. Chairman, I agree with Mr. Hillard's comment. And in addition, if we're going to be adding the city of Paxton, it would give Paxton the opportunity to do likewise. So I would make a motion that we delay till the next board meeting the consideration of this, and Mr. Bagby come back with the city of Paxton included so that they can make their selection, and also what other entity is going to be recommended to be included, whether it's the school board or if we have another one that comes in, and that way we can have a full package with everybody having been given an opportunity to discuss it at their city council meetings. Thank you, Mr. Hilliard.
Appreciate it.
I think we need to decide today whether it is the school board so we don't delay it another 2 weeks.
We won't leave it to them to come back, or do we want to make that determination?
I would make the motion that we include the school board.
Okay, so you're making a substitute motion to include mine?
To include yours.
How about the chamber?
Whatever you said, you know.
How about the chamber? The chamber
School
would
board?
probably be more interested in marketing events, I would think, rather than the school board. I mean, Bill, he's shaking his head. But I'm thinking somebody from the chamber who is familiar with, what goes on. Yeah. That's just my opinion. The school board, you think you like that?
Not to speak for the entire school board, but
I think that's...
Then I'll take my second back.
I would think the
Okay,
chamber would be
no, you
better.
made the motion.
So you're going to make the, well, my initial motion has been modified.
Yes.
Okay.
I'll take
I'm
the
saying,
board.
I'm saying
July.
defer for till the next board meeting so that Paxton and whoever else can come on board. And Commissioner Meadows is making the motion to make that other entity the Chamber of Commerce, which would be a substitute motion, I think, and I would second that, to include the delay until the next board meeting.
Okay.
What he said, yes.
Okay, I will assume that these extra 2 weeks is going to give both
Everybody.
cities the opportunity to discuss it in there. My concern is to make sure that it gets on their agenda for discussion and not have a delay beyond this 2 weeks. Okay, we have a motion and a second.
All right, and one more question, and then at 2 weeks, we will bring you our nominee for the board, correct?
Yeah, yes, ma'am, that is correct. And just because there's been a little bit of confusion, Mr. Atkinson and I met with Ms. Bowers about 6 months ago and explained this program in detail. So we didn't feel like we were surprising her, but that may not have been communicated to the mayor and the city council. The other point is that Mr. Hilliard made, these aren't operational funds. This isn't to run an event. These are coming out of promotional marketing dollars,
Right.
and they are to help market the event. And so that there's a little bit of confusion that we're going to be subsidizing events. We don't do that.
Okay. One thing I wanted to mention is that you or some staff be prepared to attend both of those in case any questions arise concerning the marketing. Okay, Clay, did you have something?
I think the question was, would 2 weeks be enough time to get it on the agendas? The city of Paxton meets on the third Tuesday of a month. That was this past Tuesday, so 2 weeks would probably not give the city of Paxton enough time, just for the board's information. I hate to gum that up for you, but it's not going to happen. There's not going to be.
And we actually have a rep from the city of Paxton. Mayor Hayward Thomas has volunteered to be their rep. I have the names of the people that y'all were considering and that they were proposing. So I'm not sure, but I will reach out to him today and see if.
Well, apparently Hayward's decided on his own that he'll sit on this. That's great. That's between him and his council, but
I look forward to be aware. It's certainly within the mayor's prerogative, but depending on how you draw the guidelines, if you're asking the council to address it, they cannot address that.
Okay.
Certainly, that's up to you.
all right. Well, so be it. If Paxton isn't available for it and Hayward's elected to go out there and take on, then we'll just work through the city of Defuniak and get them before their council.
And the first meeting probably wouldn't be for a month after y'all appoint the members. So the cities would still have time to appoint their members.
Okay. All right.
The motion is second.
We got a motion and a second. All in favor, say aye. Aye. Opposed, motion carries.
And just remind you that we are hosting the Chamber's Power Business Lunch in May, and on the 7th, y'all are all invited to be our guests at Sandestin because it is Tourism Month. And then we'll be doing the open house reopening, I guess, of the new building if we can get it finished by then, before your next BCC meeting. And that's all I have, subject to any questions.
Say May the 7th?
That'd be on the 13th, I believe, is your next meeting. So Mr. Chapman's agreed to speak and cut the ribbon. And
that's news to me.
Yeah. Jeff.
You have to come to my office to do it.
Okay. Thank you, Mr. Chairman.
What date was that, Jim?
Mr. Chairman, that's the 13th is the reopening.
Okay,
And the 7th is the chamber, right?
Yes, ma'am.
Get that, Jim.
Okay. Mr. Davis.
Mr. Chairman, thank you. Commissioners, the first item I have is a request to approve a proposed policy regarding how we go about drafting, approving, and getting contracts to you folks for approval. And the policy is set forth in the packet.
Any questions?
Motion to approve.
Second.
Motion.
Never mind.
Third.
We got a motion and a second. All in favor, say aye. Aye. Motion carries.
Doing three things
Mr.
at
Davis.
once.
Thank you, Commissioners. Next item I have I have received a request from Sean Heath, who represents some objectors that will be appearing at the Sandestin DRI compliance hearing. I received a request from Mr. Heath to reschedule or continue the May 15, 2014 hearing. Just a little bit of background. The hearing is currently scheduled for May 15, 2014, which is a Thursday at the South Walton Annex. Mr. Heath communicated with me some time ago that he had an expert that he anticipated would testify, but unfortunately that expert was not available on the date of the 15th. We have floated a couple of dates. One was May 21st, I believe, and again, your expert was still not available, I believe, that week.
That's correct. He is not available for the 21st, or my collective experts are not.
Okay, and then we floated as late as Friday, I believe, a second date of June 6th, it may have been Monday, for the possibility of having the hearing. I have not heard back from all the lawyers that are involved on that particular date. What I would propose to the board at this point is we leave the date right now as May 15th and move the continuance request to the next board meeting. And in the meantime, hopefully, I will have an agreement on a date. If we don't have an agreement, then Mr. Heath can come back if he chooses, or we can deal with the continuance at that time. But I'm doing it that way to keep, just to be blunt, to keep the pressure on to get a date scheduled. If we can have it scheduled, then we'll go forth on the 15th. I think that's a way to go about it.
Just for the record.
Chairman, before we go on, for business reasons, I'm going to recuse myself on anything dealing with this. I'm going to step down from discussion.
Understood.
And let him know that I don't intend.
Done. So if you
Mr. Heath, if you will, identify yourself for the record.
Certainly. My name's Sean Heath. I represent some folks who live in Driftwood, which is an aspect of Sandestin. It comprises about a fifth of the 2,000 or so acres that is the Sandestin Development of Regional Impact. It's approximately comprised of 700 lots, 700 homeowners, 400 acres, which is about a fifth, and more actual bayfront acreage than any other aspect of Sandestin. So our clients have a significant interest in what occurs on Sandestin and with Sandestin. The original hearing was scheduled apparently in June or February, and without our knowledge or input. And we have probably for a decade, in a variety of forms, including lawsuits, public hearings, and public requests, our clients have made requests for this very hearing. So there is no group who's probably more interested in actually having this very hearing sooner than our group, all right? And we absolutely want this, but our client group has spent literally hundreds of thousands of dollars to investigate this aspect, and what we would like is that when this hearing is decided, that the people who we've paid hundreds of thousands of dollars literally to research all of these issues be given the opportunity to testify. And so I actually worked out last night late that all of my experts and I cleared our calendars for the next proposed date, which came last night, as June 6th. So that date is available to us. It works for us. We will be here. We will be ready. I have preserved a variety of other issues via emails with Mr. Davis as to things that we still don't know about this hearing and that are fundamental to the process. One is what is actually going to be decided has still not been identified, and we're less than a month from the scheduled hearing. Who or how it's going to be identified, or the procedures of that hearing have not been identified, and there is no mechanism presently in the law that identifies how they are identified. I did see your message this morning on the authority for the hearing. And then the last issue that I have raised with some specificity is who will decide this. There will be 4 people apparently, as we sit now, who will sit as judge and jury over an aspect of Walton County that is probably hundreds of millions of dollars of value, from which our clients have significant personal value and risk in. And so as early as I could in the process, I've identified what we believe to be bases for some of the people who will vote on this to not sit in judgment of it. Now, what I recognize from Mr. Davis sent me an email this morning, actually, that says that decision of recusal can actually be made up until the moment of the hearing, or in fact, probably in the hearing. I realize that. But if it doesn't make much business sense to not decide that early when we have the information, for example, if we wait until the day of the hearing or during the hearing, then not only my client but others will have spent hundreds or tens of thousands of dollars getting prepared for having their people, their witnesses, travel to the hearing only to arrive to find that a recusal results in a non-quorum such that the hearing has to be continued again. So I raise the issues still. We don't know what exactly is going to be decided, how it's going to be decided, or who's going to decide it. Nevertheless, preserving those reservations, June 6th works for us, Mr. Davis.
And thank you, Mr. Heath. And I have not heard back from the declarant's attorney, although I talked to him briefly yesterday. So again, my proposal would be leave it on. We'll come back on the next regular meeting and see if we have a date settled. It may be that date. It may be another date. And listen, I'm not trying to shortchange Mr. Heath. I have some sympathy about getting witnesses to hearings. Mr. Vorbeck and Mr. Matthews also have experts and witnesses they have to clear times with. And so we're trying to be expedient, but also be relatively efficient in the process. Let me also say the staff has, to put it mildly, worked diligently in the last month and a half to review, once again, the annual report submitted by Sandestin, and they are committed to producing a response and a report on compliance on or about May 1st, and I'm holding them to May 1st, and I know Wayne flinches every time I say that because it's a volume of material we've identified that needs to be reviewed. That report, the annual report, and that report will be the basis for what issues will be reviewed, understanding that objectors, Mr. Vorbeck, Mr. Heath's clients, would have an opportunity to raise other issues if they choose to, so long as they're relevant to the compliance issue. Now, one last thought here. Our code and our policies and procedures, there's a Florida administrative rule which requires us to have policies and procedures in place for monitoring compliance and enforcing compliance with the DRI. We don't have that type of a written policy. We're working on them, frankly. And what I've proposed is what I've proposed we do in this instance is essentially what the policy is going to be. Having said all of that, it's still my goal. Sandestin needs an answer. These objectors need an answer. So to some extent, I'm holding everybody's feet to the fire as hard as I can, understanding their need to get their folks here. So again, my suggestion is we'll revisit in 2.5 weeks, 3 weeks before the next meeting. If we don't have a hearing date, we may very well go forth on the 15th, but I feel fairly confident these lawyers are going to work together with me, and we'll have a hearing date set.
One final point, if I may. It was pointed out, Mr. Davis, yesterday to me by the Department of Economic Opportunity, who is the state agency that monitors developments of regional impact statewide and is, I'm aware, monitoring developments with regard to the Sandestin DRI. They pointed out to me that according to the information that's available to them as the published public information, that they see May 13th as being identified formally by Walton County as the date of the hearing, which is contrary to what we have discussed. And I just want to bring it to your attention. That's what they see publicly.
We've talked, and we're talking again tomorrow about that very issue. Yes, sir.
Mr. Vorbeck, will state your name for the record.
Gary Vorbeck, and I represent Sandestin Owners Association. I appreciate the opportunity to speak in front of the board. As you're all aware, the SOA, Sandestin Owners Association, has pushed and insisted on and encouraged that the developer Sandestin be required to follow the law. That's been their mantra for literally years. And part of that is you've all agreed, and the county attorney has ruled that Sandestin will be required to follow the comprehensive plan like anyone else and follow the land development code. And therefore, major developments will be heard properly and not be done as minor developments and not come in front of the planning board and board of county commissioners. But one of the parts of following the law is make sure they follow the development order. And that's required by statute, and Mark has made you aware of that, and that's what this hearing is being set to have a quasi-judicial hearing to make this determination. But one of the problems I'm running into is you set it for the 15th, and that's fine, and the 6th fine with us. But I guess I'm kind of in a quandary to wait. I have to get my experts to be on hold and prepare for the 15th. But it could be the 6th. And so I think we're in a difficult situation and going to run the bill up for the client. Needlessly, I have no problem setting it for the 6th. That's fine with us. But I would like to do it. You see what my problem is? I got to prep the witnesses. The witnesses got to have things set. They're in demand other places. And so it's difficult for us to do that. Now, I understand if witnesses can't make it on the 15th. I'm with Mark. I'm very sympathetic to that because there's dates my witnesses can't make it. So it'd be ridiculous not to be sympathetic to that. And so I don't have a problem with being changed for the 15th. But I don't want the unknown for 2 or 3 weeks, and then because my witnesses are going to beat me over that head and shoulders. And so, excuse me. So we're going to have people attend this that are members of the Sandestin organization, as you know, are several thousand strong, but they're going to attend it, and they have to make plans to attend it. So it's difficult. I was hoping to walk out of here today with, if it's June 6th, it's June 6th, and then I can plan it, my life will be fine. But the only thing I disagree with, Mark, is the unknown is killing me.
And listen, again, I'm sympathetic to that, but all I'm asking is let's leave it on just to hold everybody's feet. My concern is if we say we're going to cancel the 15th, then these folks have no incentive. Not that you haven't.
Oh, believe me, we got incentive. Yes.
You will have incentive to work with me to make sure we get a date scheduled soon. And I know that's being a little bit harsh. But
we have an incentive. I believe Driftwood folks have incentive, and obviously the developer has an incentive. So I think everybody is here is strongly wants this thing to happen and happen fairly soon. So I don't think that's a problem. But my problem is if you keep me in limbo, I don't know if I can keep my witnesses in line.
It's up to you folks.
We've changed it, twice. Why can't we just say the 6th? And then everybody, then there's and everybody has to, get on board and line up. That's a Friday. And
Commissioner, not to interrupt, but I don't have a problem with that at all because
Okay.
I did float that date.
Okay.
I just want to make sure we're clear for the record. I have not heard definitively back from the developer that his folks are available
June
that day.
6th. Okay, well, I think we need to give them a deadline and say, tomorrow noon, June 6th.
Commissioner, I agree with you in that respect as far as setting a date certain.
Mm-hmm.
That is the date certain.
Mm-hmm.
It doesn't move beyond that again.
I
That's
have
my opinion.
Yeah.
Because y'all, it's up to y'all. Y'all the one that's got a vested interest in what's going on here. And you got to make whatever arrangements are necessary to get your people there
Correct.
to be heard.
But I've already been lectured this. If we're going to move the 15th, I need to know it right away. I mean, these people are.
I understand that.
So if we're going to do that, I would like it decided today if you can do that.
And Commissioner, then let me do it this way. That way, I'm a little more comfortable. But I understand what you're saying, both of you. Why don't we set it for June 6th or any other date that we agree upon? And then that way, if something's wrong with the 6th for anybody, I'll have the opportunity to reschedule for another
What
day.
about you, Mr. Heath? Is that acceptable?
Yes, sir, that's satisfactory. If we set it as of walking out of here as June 6th, and then if there emerges a need, then that's brought before you.
And
because
again,
2 of the 3 of us agree.
And again, I'm only saying that because I have not heard from the developer.
Can we give them the developer a deadline? I mean,
Commissioner, I'm going to be partly gone tomorrow at a funeral.
I know.
Is Thursday at noon okay with everybody?
yeah, get your people, call them, make sure, let's get this set.
Commissioner, the only thing is that kind of is it set? I would just if you say I think what was just suggested that it's June 6th, and if there's a problem, then Marco will arrange it, we'll go on, because all of us want to be here. Nobody wants to delay this.
Right.
Well,
So
Let's just say June
June
6th.
6th.
or any other date that we've agreed upon. And that way I don't have to come back to you guys to get
Okay.
another date
Yeah.
with other
I have no
issues.
problem with that whatsoever.
And if anybody comes up on June 5th and says, somebody in their family is in the hospital or something, I want a note from the doctor.
Yes, ma'am.
I'm serious.
I understand.
I want verification, because we've too many times gone down that route and go, by the way, this, that, and the other, and
I understand.
This is Fisher gut bait time, as my granny would say.
And that's what I was trying to get to.
You need a motion, Mr. Davis.
Yes, I do, actually.
All right.
So move that we move it to June the 6th.
Or any time the 4
where what
lawyers.
time? Where what time?
It needs to be at
9
South
o'clock
Walton at
at
9
South
a.m.
Walton Annex.
Okay.
Take all day.
Nine
Okay.
o'clock at South Walton Annex.
Okay, got a motion?
Second.
Got a second? All in favor, say aye. Aye. Motion carries.
Thank you, Commissioners.
Thank you very much.
Thank you, gentlemen.
Thank you.
Done that.
Commissioners, the next item I have is I'm asking you to formally reject the settlement offer and authorize me to end the mediation with the Nippers and to continue both the lawsuits and the code enforcement process. I believe I have direction to that extent, but because that's official action, I think we need to take that in official action at the board table at a publicly advertised meeting.
Motion to approve.
Second.
Got a motion and a second. All in favor, say aye. Aye. Motion carries.
Thank you. Commissioners, next item, I'm embarrassed to say, but back a year ago, you folks asked me to draft a letter of support for Gulf Trace Owners Association to build sand dunes and restore sea turtle habitat using BP funds. Yesterday, and I've drafted it, it's in your packet. I had met with these folks. There's been an issue raised by, I believe, Mr. Flint, I don't know if Mr. Flint's there, he is, about the source of funding. And looking at my, quite frankly, not voluminous notes on the meeting, it's my recollection that it was a different pot than the pot that the county would receive its funds. But I couldn't swear to you on under oath right now that's the case. And then the second issue I think Mr. Flint raised was whether or not we would be bound to do this for other folks. And I will tell you the short answer is no, you can choose to do it for one or not do it for another. So that's my recollection. I apologize for it taking a year to get back to you. This one just slipped through the cracks over the past year, but it's before you now.
All right. Well, if I understand that, all we were asked to do before was to support
their application.
Their application go forward. And if I understand it, the money that they are requesting is not going to come from any of our pot 1, 2, or 3.
That was my understanding from the meeting, but my notes weren't perfect, but that was my understanding.
Mr. Flint, you come forward, please.
It would. I believe it was a DEP special, preliminary pot of money that you could apply for. Anybody could apply for.
Yeah, that's
That was my understanding.
Right. I looked at the.
State your name, please.
I'm sorry, Mike Flint from Miramar Beach. I looked at the records that were provided from the minutes, and it just said DEP money. Now, I'm not sure if that's a special pot or the DEP money that you would consider pot 2.
No.
And those things are interesting, but not relevant to my real concern. My real concern is choosing to give someone support for their project without a standard for them to meet for that support. A disappointed applicant for a project might view your approval as arbitrary and capricious if there are no standards. It's simply you felt good about it that day. So my suggestion is consider setting standards for providing letters of support for any projects. With a large amount of money involved, people, if they find the smallest chink, they will attack with a suit. And I noticed there's a matrix of suits listed in the agenda today, and this could easily add to that list. And that's my suggestion. Consider setting standards for providing letters of support for specific projects.
I would agree going forward.
Yeah.
But since we approved this a year ago and these people are waiting, I mean, I think we ought to give them their letter and then look at setting some standards, because, they want to rebuild their dunes. They're going to have to comply with DEP requirements. They're not going to get by with anything that the county wouldn't agree with, I don't think. So,
yeah. And Pot 2 money, by the way, is council money. That's of the three pots, it's all the states, which it wouldn't apply to this one. And also, of course, Pot 3 is the consortium. So this, the way I understand it, this is strictly some money that DEP got their hands on, and it's just DEP money.
These are DEP grants.
Yeah, grant. It doesn't concern the restore pots.
And we get a lot of requests to sign grants for other folks. So, if we need to come up with a guideline, but I was pretty sure that we had a guideline, that it had to comply with all of our land development code and comprehensive plan guidelines.
Okay. My purpose is served. I believe in what the Gulf Trace folks want to do. It's a smart thing to do. It's good for their area. It's good for the environment.
Right.
And you have discussed the issue, so that satisfies my concern. If you're happy, I'm happy.
Mr. Folks, do you have some comments? Come forward and state your name for the record.
Good morning. I'm Richard Folks with representing South Walton Turtle Watch today. South Walton Turtle Watch supports restoring the dunes and sea turtle nesting habitat. However, we would like to point out, if the desire here is to restore sea turtle nesting habitat, that they could start by removing some of the old sand fencing posts and the parallel to the water sand fencing that exists in front of at least 3 homes in this small development. We know Mr. Perry, who is the president of the Owners Association, is aware of the violation because we talked with him about it on July 26th when we documented the violation. We were also present when Reginald Bradley with FDEP talked to him about the violation on September the 5th. We would love to see BP Restore funds used in this location, and we would love to see sea turtle nesting habitat restored. But if restoring the sea turtle nesting habitat is the reason to obtain the funds, we would encourage them to take steps to remove these impediments now before sea turtle nesting starts in May 1st. It's an easy, inexpensive place to start. Thank you.
Thank you. Any other comments? What's the board wishes?
I would motion that we go ahead and approve, go ahead and write the letter because of the circumstances. They have to follow our land development code, our comprehensive plan. They have to follow DEP's thing. And
the Corps of Engineers. Add in the Corps of Engineers.
And the Corps of Engineers.
Yeah.
So I would motion that we go ahead and write this letter.
Right.
Second.
Okay, we got a motion and a second. Any further discussion? Seeing none, all in favor say aye. Aye. Opposed, motion carries.
And then we could use Ms. Meadows' motion to perhaps draft.
And I'll get Mr. Flint.
Yeah, it needs to say that. And since this was adopted years ago and we didn't really discuss the sand fencing and all that kind of thing, we need to add that into the probably thing that there's no outstanding violations, that kind of thing.
Yes. Thank you. Next item is number 5. It's a request direction to renew the agreement for professional services with Marlowe and Company for professional lobbying services. There's an option to renew this agreement for a 1-year period. We've prepared the option, but we wanted you guys to let us know if you want to renew it.
Well, I have a question about it, Mark. Just reading the extension verbiage, there's no reference back to what the contract terms were or fees associated with that. And I just wondered if there shouldn't be a statement in there that this extension applies back to whatever the original terms of the contract were for 1 year.
We can certainly add a sentence that all other terms would remain in full force and effect.
Because right now it doesn't say anything about all that.
Okay. It does say in the,
Oh, yeah, it does. I'm sorry. All other terms of the agreement, last paragraph.
Last paragraph.
All of the terms of agreement remain in full force.
Okay, I'm sorry. I
That's okay. I
stand
missed it
corrected.
too.
Okay.
Motion to approve.
Second.
Got a motion and a second. All in favor, say aye. Aye. Motion carries.
Next item is a request to approve and or ratify the actions of the Office of the County Attorney on its pending litigation status, those items which we are handling in-house.
Motion to approve.
Second.
Okay, we've got a motion and a second. All in favor, say aye.
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 And
Opposed, motion carries.
Commissioners, also there is a report from neighbors Gibbling and Nickerson on the litigation that they have handled and are handling for the board, and we'd ask you to approve that report as well.
So move.
Second.
Okay, we've got a motion and a second. All in favor, say aye. Aye. Motion carries.
Commissioners, Commissioner Meadows, myself, Mr. Jones, and Bob Hudson from the South Walton Mosquito Control District met a week and a half ago, I think, and discussed an issue regarding identified mosquito control ditches that come into play when development orders are issued. We would like direction from you folks to do two things. One is to draft amendments, necessary amendments to the Land Development Code and to our procedures so that we can establish buffers, for instance, for those mosquito control ditches, so the South Walton Mosquito Control folks would have access to do maintenance on those ditches, and also to give them the opportunity, although they're doing it now, we'd like to include it in our policies and procedures or ordinance, give them the opportunity to participate and have a sign-off at the technical review stage.
And this, my understanding, is for all new development projects.
Right, forward.
In other words, you can't go in and tell somebody that, by the way, you've got to provide a. So this would be for all new development orders, my understanding is.
Has there been a discussion of what the width of these easements are or buffers away from the ditches? Have y'all got that far along?
Yes, sir. I think the initial talk was
25
25 feet. I may be wrong, but I think it was 25 feet on one side or the other, yes, sir.
Because they need to drive.
Get heavy equipment down those ditches.
Okay, so we're not talking 25 feet each side of it.
I think we were. I think we were saying 25 feet both sides.
Mr. Hudson, identify yourself for the record.
For the record, my name is Bob Hudson, and I'm a member of the South Walton Mosquito Control District Commissioners. When we met with Commissioner Meadows and
Larry Jones,
Mark Davis, as well as Larry Jones, with our director, Mr. Ben Brewer, who's here, the issue of where that 25-foot buffer is, Bill, came up. First thing we were asked to do was identify our 46 ditches and make an overlay within the GIS system. Ben, I think we got that completed yesterday. We've made some changes that were made since that was originally done. We'll submit that. Commissioner Chapman, our issue is, number one, those ditches were originally dug years ago in what I would call very wet areas. In the past, we've had very few issues with those ditches in terms of encroachment, in terms of people putting water in those ditches beyond what their capacity was designed for, because there wasn't a lot of development that was taking place there. As South Walton has, I'll say, burned a lot of high and dry land, we're beginning to see a lot of development requests that are in those areas. And what we're trying to do is to protect the ditches that were dug for mosquito control. They're not stormwater ditches, but yet we're finding people are beginning to try and use those for stormwater. We're beginning to see tremendous flow as people do things. They've thrown water in different ways, different areas. And so our attempt is to try and protect those ditches in terms of their intended use, to work with the planning department, Commissioner Chapman, in terms of where that 25 feet is, what we don't want is 25 on this side one time and then 25 over here, which means we've got to install bridges and things of that nature. It may be that in some areas we can use a smaller excavator to do the work to where we could reduce that in terms of a buffer. But the main issue that we're also having is developers are trying to develop as close to those ditches as they can, and we've already seen some areas where our maintenance is blocked because a building has been installed or a fence has been installed. If those ditches are not maintained, we're going to have a real problem, and that's the request, Bill. I think we're trying to work through that. The meeting that we had with Mark and Larry and Commissioner Meadows, I thought was very well received on their part, and we were very appreciative of their listening to our story about what was going on.
Good, thank you.
And I think one of the ideas we floated with, there'd be some sort of checkoff by these folks. There may be areas where they just simply, for whatever reason, don't need the 25 feet, or and that would be the reason they would participate in the technical review, because there might be areas where they need it on one side and don't need it on the other side for whatever reason. So we were going to kind of give them a check off or an ability to waive what they needed.
Yeah, I think as we go forward with this ordinance, Mark, or resolution, or whatever it is, I'm going to defer to the legal people in terms of what the title of the document is. But anyway, we're willing to work as partners to find a solution that meets development needs as well as our needs to maintain those ditches and everything. We do have some ditches, Mark, that we may abandon in the sense of not maintaining them as we have, because development has occurred around and they no longer are truly there for mosquito control purposes. They're being used by developments and things of that nature for stormwater, and we discussed stormwater with Commissioner Meadows as well, but we just want to make sure that everything that touches those in some way is looked at to make sure we're not impeding that. That's the intent.
Thank you.
Mr. Hudson, real quickly, help educate me here. Are the mosquito control ditches only in the undeveloped areas, or are there some in developed areas too?
Well, you have had development that have occurred around those ditches in some areas, particularly on the Miramar Beach side. As we go and you're starting to see development beyond 331 and things of that nature, and then some of the infill areas south of 98 between 30A and let's say 395, there is some large parcels of land that are in there, and those are not what you'd call high and dry areas, Bill. We've been working with a developer that's trying to do some development in those areas as he's trying to find a solution to his issues in terms of, I think it's a 10-year event or whatever it happens to be. But
thank you.
It's very difficult for us, Mr. Commissioner Enfield, to abandon a ditch. But if you have a development built around one of those ditches, and sometimes if you live, they expect us to maintain those and mow the 25 feet like a golf course. And so we're trying to work our way through this. Walton County is the only district, I didn't even know this until Commissioner Meadows mentioned it the other day, that stormwater is not controlled by the water management district. And in a lot of areas where they have those ditches, there are very strict requirements in terms of what goes in them, that they're fenced and a lot of other things. And I understand someone passed a bill that excluded Walton County from that kind of control. But hopefully, Bill, we can go forward.
Thank you.
Anything else? Thank you.
Commissioner, I just need a motion and a second to direct staff to start that process.
So moved.
Second.
A motion and a second. All in favor, say aye.
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 Opposed, motion carries.
Thank you, Commissioners. The next item I have is you asked me to report on whether or not I believed a possible sunshine law violation had occurred regarding various contracts with the Atkinson Law Firm. I have prepared a report to you, and I attached lots of documentation to that report so you would have a sense of the background. My conclusions are set out in my report to you. It's presented to you for informational purposes. If at some time you want me to answer any further questions, just let me know, or if you want me to take any further action, just let me know. But it's presented to you for informational purposes only.
Okay, thank you. Next.
Next item is a request to approve a contract with Kurz and Down Research LLC. This is a TDC contract. You awarded the bid, I believe, at the last meeting.
Motion to approve.
Second.
Motion and a second. All in favor say aye. Aye. Opposed, motion carries.
And Commissioners, the last item I have is one of the requirements of Chapter 125 for us selling properties. We have to establish by resolution the highest and best use for the property we are seeking to sell. This deals with the Brigman piece of property, and it's a resolution finding the highest and best use for that property, and then we'll publish that notice in the paper.
Does this include the additional 3 acres from last time?
My understanding is it turned out to only be 1.57 acres.
That's
so
correct.
It does, yes.
Okay. Motion to approve.
Second.
And as a point of information, the contract we're drafting is one contract for both parcels. So. And Commissioners, thank you. That's all I have.
Got a motion and a second. All in favor say aye. Aye. Opposed, motion carries. Okay, Commissioner Enfield. Oh, excuse me. Commissioner Meadows, you have anything?
No.
Okay. Commissioner Commander?
No, sir.
Mr. Enfield, proceed.
Thank you, Mr. Chairman. First thing I'd like to talk about is you and I are basically new to the board, and Ms. Meadows had been absent for 4 years. I've seen when things have come in front of the board about ordinances, we've had a lot of sometimes disarray as to what's going on, where it's going on, when the public's had a chance to comment on it. And I'd like to standardize some procedures so that when an ordinance does come in front of the board, a number of things have already happened. Number one, there's been public input. I think that's critical. Number two, we've got identified what is the problem that we're trying to address, and I think that's going to be key. I also think we need to get the county attorney's review on it so that what we are trying to accomplish meets with the legal standards that are necessary. We need to know what it's going to cost to do whatever we're asking to do, and then I think the important thing is enforcement mechanism. If we've said something that a violation is going to occur on, how do we enforce it? So I'm asking the board to consider this as a policy for future ordinances that are brought in front of the board so that everyone, including the public, has had ample opportunity to review it, ample opportunity to comment on it, and when the board is given it, we've had sufficient information in which we can make an informed decision.
I certainly agree with you. You must have looked at my board book, because I have a little piece of paper in front of my board book that I always ask myself, what's the problem the ordinance is trying to fix, who will enforce it, and is it within state statute? And so I certainly agree with you.
And certainly we can have it brought to us up front instead of having you to sit there and comb through it to see does it meet all of these standards. We can set it as a policy that in the future when these things are brought to the board, all these things have been done, and especially the public input.
And I think,
and that's where, I'm sorry, go ahead.
No, I think that this is happening now. There's a couple ordinances that have been floating around for at least a year. I think everybody that's had a chance to comment on has. In fact, some of them even more so. I think that with regard to the cost of an ordinance, I think that's going to be somewhat difficult to nail down, because a lot of these ordinances are, let's say the clearing ordinance. We already have code enforcement in place. How are you gonna determine what it's going to cost you to enforce that ordinance? The question we ought to be asking is, how much is it going to cost us if we don't have that ordinance? It's going to cost us. We've got $11 billion worth of real estate in South Walton, $1 billion in North Walton. And the way you keep those values up is that you adopt ordinances that preserve your environmental resources. You ordinances that don't turn us into Panama City and Destin. So some of these ordinances that we're looking at, and I think it's pretty easy to explain why an ordinance is needed. I mean, I think most of these are kind of no-brainers. Clearing within 300 feet of a coastal dune lake protection zone. It's in the comprehensive plan. That's why you do it. So while I think that we need that, I think that that's already going on. I think Mark is looking at all these ordinances and tweaking them. They're going to us first, maybe perhaps from the planning department. They're coming to us and saying, do you want to pursue this? And we're looking at it saying, yeah, perhaps we do. Number two, we workshop these things, sometimes to death. Number three, a lot of people do not weigh in on an ordinance until it is before the Board of County Commissioners, the meeting of. People have busy lives. They're not paying attention to what all we're doing. So I think that a policy is necessary, but I think we don't want to make it so cumbersome that, 2 years later, we're still talking about how are we going to deal with parking? Is this a real issue? How are we going to deal with, and the cost, if you're going to quantify the cost, how much is it going to cost us to pay the planners to quantify that cost? That's an extra load on them. In that cost, what's the quality of life cost to it? I mean, what's the unquantifiable to that ordinance, such as the digging dirt in farmers' land? What did that cost the county to look at? Well, we all agreed that maybe that's a good idea. It really helps the farmer. How are you going to quantify that? That's what we're here for, is to decide what makes sense and what doesn't. And so I have a problem with loading everything up on these ordinances because I haven't seen any ordinances fly through here without really well reviewed since I've been back on the board. I mean, I'm waiting on a noise ordinance for 1.5 years. And do we agree that one is needed? How much is it going to cost? How much is it going to cost if we don't do these things?
Commissioner.
Commissioner Meadows makes some valid points. What I'm trying to accomplish is that when it gets to the board, all of these things have been flushed out for us with information. I have seen, while we've been here, ordinances set back because we don't have the enforcement mechanism identified, or some costs quantified, if they're quantifiable. And I certainly appreciate your comments with regards to what we're trying to preserve. Yeah. What I'm looking for is if we can come and have a standard so that when it gets to the board, it should be in a position that if we can make a decision, we make the decision because these things have been done. But I have seen many times where the board, even prior to my tenure on here, where the board has had to ask, what about this and what about that? And those are the kind of things that didn't come to the board in the package so that they could be reviewed. And some other things that may come up can also be answered. But it gives you an opportunity to say, it's been through these processes. If there's costs that are identifiable, and it may not be. It may be something that currently can be done, and just say these costs, there's no new costs or costs are not identifiable. We're at least knowing that when we get this thing brought before us that it's been considered and somebody has looked at that. And I just think, again, if we've got a basic step approach, so it comes to there in some standardized format, and even then, if you've got additional issues, we should add that to come in there. But then the board has as best informed possible package for it to deal with. And that's the purpose of me making a motion for a policy to do this.
Okay.
Are you asking that we just review this and come back at the next meeting? Or?
You can, but I think that we need at some point in time to adopt a policy with regards to whether it comes back next meeting after review or not.
And that's fine. And that's fine, and Commissioners, I'll draft something. We actually have an older, December 2007 policy that was passed. What I'm hearing is what Commissioner Infeld is looking for is some things that need to happen before the first step is taken under the old policy. So What I would suggest is let me email this one to you guys, and you email me back suggestions individually, and then we'll take a shot at drafting something.
But I think we need to know what we're doing now and what Mr. Enfield's talking about doing. Let's see what we're doing and what we're not doing.
Yeah. And there's actually a step in here I'd like to take out anyway. So.
I think part of the process will be, as the commissioners have suggested, is perhaps a checklist or a cover sheet on any proposed ordinance that says legal has reviewed it. These are the comments from whomever it may be impacting. So certainly to get you as much information as you can to make a good decision.
It's similar to when we do the planning stuff, and it's got a checklist things of, these are the comments of, and it gives you the opportunity, at least as the board, to know what some of the pros and cons have been that have come up that we may not be aware of just because we're sitting here at the dais.
To add to that, while we're talking about it, I think if you're going to do this, you need to add some time frames. If you send it to the attorney, we need it back in 30 days. If you're going to have public input, you're going to have a 60-day period, because what happens is the can keeps getting kicked down the road. 2 years later, we're still trying to figure out where we are in the process. And if it's, whether it's politically expedient or not, I think that we need to move these along. We either go up or down and not just keep kicking the can down the road, because there are some ordinances that we've looked at that needed to be adjusted when I was here in 2004. And, I'm not complaining, but I get all the calls. I know y'all get a lot too, but I can't keep telling the constituents, well, we're working on it, we're workshopping it. It's in draft. It's in the attorney's office. It's in the workshop. Pretty soon they go, Miss Meadows, I don't even know why we're talking to you. And that's the stage that we're getting at now. We're at the stage now where we got a lot of people upset about things that we're not taking care of. And I hear about it, and they talk about y'all not hearing about it, not doing anything about it. And I'll pass that on to you. But we're at that point. So we need some time frames. If this thing goes to the public for 60 days, and then we take it to a public hearing, we have 2 public hearings, and then we either go yes or no, unless there's some extenuating circumstance.
Good comments.
Just so I'm hearing clearly, time frames, procedure, and costs that are quantifiable.
To look at the ordinance. Sheriff's Department, how long do they have? They took, 9 months to look at the noise ordinance? I mean,
Joe. You're out of order.
The thing, it's and you and I dealt with that. The fire department, whatever department it is, we need them to respond to us in a timely manner.
And Commissioner, I'll be happy to get something. I'll send you what's currently in place. There's some things in here. One thing I'd like to take out of here because I think it's cumbersome and doesn't help us any, frankly. And then I've looked at some other counties when I saw this on the agenda, and I think Larry brought it to my attention as well, on what not only their steps are, but what they present to you in terms of staff report. And I don't want to get into I don't know if anybody's ever seen a legislative staff report that goes with a bill. We don't want to get in that kind of detail, but there's something that's I'm sure easier and shorter that we can get to you guys through Larry's office that will make sense.
Mr. Chairman, I'm sorry to interrupt. I'm asking to be excused. I have a funeral.
Okay.
So we'll get it back.
Just one more thing, too. Sergeant Preston, I do want to say, and I didn't put this on the agenda, and I think my thing is that spring break is over, and I want to say that the Sheriff's Department did an unbelievable job. I think you see Destin. I think you see Panama City, the reports on Panama City and the reports on Okaloosa County, because I think everybody that was here went over there because of our sheriff's, our sheriff's diligence and addressing this. So I would like to thank them in public for that awesome job.
Okay.
Thank you, Major Preston.
I'm sorry. I keep.
Ms. Harris, Come forward, please. State your name for the record.
This won't take but a minute, but Mark will tell you at the planning board meetings, every month I bring up, can code enforcement just enforce the ordinance we have, like the scenic corridor ordinance? We have tables, couches, chairs, sitting on the site, on the bike path. I'm not on Scenic Gulf Drive, but on Highway 98. We need to figure out why code enforcement. We've got a dollar store with T-shirts, with a rack, with T-shirts flapping in the wind, and when the wind blows hard, the T-shirts blow all down, and when I walk the dog, I pick the T-shirts up for him. We need not to just sit around and pass ordinances. I've been begging Mark since the first meeting I got on the planning board, please get code enforcement. I beg planning and code enforcement. Just enforce the codes we've got. And if you can't enforce the codes we've got and the ordinance we have, there's no sense passing anymore.
Thank you.
Yeah, and I appreciate that comment, because that's part of what we're trying to say here is that if you're going to have an ordinance, what's the enforcement mechanism? And her point is right on.
Okay. Well, unfortunately, I did travel 98 the other day. And while down there, I did see several locations, and I'm not as well versed on the scenic corridor that maybe Ms. Meadows is. But what I did see, I do not understand why it is still today not being taken care of. When you see beach chairs, all kinds of water type of amenities that are being sold. I didn't see the T-shirts, though. I didn't see that part of it. But there's a lot of stuff that I look out there and I see, and I think if you go back a year and a half, as long as I've been on the board, one thing I've always preached is the enforcement side of it. If you got it, enforce it. If you don't have it, either get it fixed or do away with it. So I see Mr. Dyes has come up here. I welcome your comments, sir.
Mr. Chairman, thank you for your comments. As we speak right now, we have 2 officers that are available. We have one that's sick. We have interviews tomorrow to hire an additional officer, and we hope to have that on board when we make the selection. We hope we have those folks on board very quickly, but we will look at those things. Code enforcement is a difficult process. I've said it 100 times. We've covered the whole county, and we don't always see everything that you all see. As far as the scenic corridor goes, there is a pending ordinance. We have had some issues with the outdoor display of merchandise. We've got a pending ordinance that's out there that has some relief, I guess you would call it, for the outside display of merchandise. We also have the sandwich board ordinance that's coming forward, which is also one of the comments we've had. So those things are difficult to cite, I guess, because they are mobile. They do bring them in and out. Code enforcement is fairly easy when you have a permanent building that's in non-compliance, but when you have these things that do go in and out, it does make it difficult. But we will, again, we will do our dead level best to try to.
All due respect, you don't go out and move in and out a 500-pound ice machine off the front porch.
Right.
And so those things have been there, and some of them, again, I ain't down there all the time, but I keep seeing them, Mr. Dyes, and I don't understand. I understand there's a process. You got to cite them and warn them first, cite them, and then go through all these progressive hearings and all that. But, my God, some of this stuff was a year ago you seen it, and it's still there today. Why haven't we got it any further down the road?
Well, the ice machines and things of that nature, we've discussed this before, but several years ago, 4 or 5 years ago, there was a decision made that anything that was under the awning of a building was considered to be non-outside display merchandise. And that's something that when I look at the ordinance, I didn't see that. We've changed our policy, but we still have those in place. And so those are moving forward. We've quite frankly, with the pending outside display merchandise ordinance, we've kind of halted that a little bit until the outcome of that particular issue. I know that we were getting ready to enforce that a year or so ago, and we had several people come to the meeting in South Walton complaining about our enforcement of that, and so we kind of took a step back on that.
Well, I
quite
think
frankly.
that would go back to what Commissioner Meadows was talking about. If we're going to have these things, there ought to be some timelines in place so it doesn't drag on for 6 months, 8 months, a year. Go ahead, Matt.
If I could, Matt Carpenter of the Planning Department. If I can remind this board that we took some very significant enforcement action on outside display of merchandise in the time frames that you described, but what that did is generated a large crowd of people that came to this particular board and asked for some relief for outside display of merchandise. And in that direction, we relaxed enforcement of this because this board says we need to provide some relief for those folks. Now, we have brought the ordinance back, and it has stumbled at the Design Review Board a number of times. We finally got the business community and our planning board to recommend an ordinance that would allow some limited outside display of merchandise, and that will be on your next agenda for consideration of adoption. Okay. But in the meantime, we're trying not to overly enforce this because of the direction of this particular board, which is not exactly what we want to do. It's not what we think is right, but we're looking at the politics of it and the direction from this board to provide some amount of relief. That ordinance now is about to come back before you.
Okay, thank you. Any other questions, comments?
He's absolutely right, which backs up my example of, we get in the process of adopting an ordinance and then we kind of back off on everything. Well, 2 years later, we're still talking about that ordinance. And so I think we need to give the Design Review Board, they get 2 shots at it. We can't keep ruminating it around. If they deny it, then it's a denial. It goes to the Planning Board, they get 2 shots at it. Then it comes to the Board of County Commissioners because we can't just keep, regurgitating it around and around and around because we need to take care of business, and we are not doing that. And we're the board, the buck stops here, and if we don't take care of business, this is what we're getting.
Okay, thank you. What do you need on this?
Mr. Davis has indicated he is going to bring back to the board in a written format a policy that would address these various issues that we've had.
All right.
I don't want to make it too hard, but just so we're clear, I'll email you what we currently have in place, and then if you would, email me back just ideas and suggestions, and then I'll get you something back pretty quickly. I do want to say, and Commissioner Meadows is right, the Design Review Board, and I'm going to sing their praises for just a minute because they did work extremely hard, took a lot of time, a lot of effort. It probably took too long. I'll tell you that, but they did take a lot of it, and I tell developers that call me about some frustrations they have with the Design Review Board that they ought to use those folks because those folks are, they're architects and professional engineers, and they're folks who can help them. But yeah, they did spend a significant amount of time on the outdoor display of merchandise, and the one that's coming has been vetted and it will be here next week. And I mean, between the business community and the Scenic Quarter folks, it's gone back and forth a number of times. But I like the idea, frankly, of time frames because I'm one of those folks who works better with a deadline, so that wouldn't hurt my feelings at all.
Okay. Mr. Enfield, you have another?
Yes, sir. Mr. Chairman, I do. And at the last board meeting, there was discussion about the proposed Walton County Sports Complex, and there were 4 different properties that were offered. And at that time, I had asked to get some additional information with regards to financing and some issues, and I've heard a lot of things from the public since that point in time as well. And so I don't want the issue to get delayed, so I'm looking to move it forward. And part of it would be is that let's identify which of the 4 properties that we really are interested in doing. I'd like to have the board make a legislative finding that there would be a significant benefit to tourists involved so that we could possibly use TDC funds for it. There would then be a requirement of at least 2 appraisals for the property, and then have legal research as to whether or not we could directly use TDC funds to pay for it, or would the Board of County Commissioners obtain financing for it and then lease it perhaps to the TDC for their covering of the costs and maintenance of it. And so while I don't have a particular property identified right now, I'd like, perhaps at the next meeting, the two participants that were leading this thing, which were Mr. Bagby and Mr. Jones, to perhaps offer the top two for the board to consider, and then move forward with these things so that we can actually move forward with obtaining one of the four properties that are recommended for additional play area south of the bay.
I think what you're going to have to do, if you're going to be looking at TDC funds, you're going to have to go to the state and, of course, ask the question, which I think we've already asked, but I think it said that there has to be a definite nexus between, the use of the park. So and the TDC Advisory Council, the TDC Destination Improvements Committee will have to review it, and the TDC Advisory Council will have to agree to it to spend TDC money. Now, when we went through this before, we talked about this, and the local people want a place that they can go and they can reserve. I mean, I have a list of all the number of people that we have down there now playing ball and what we've got to offer. If you have the TDC advertise it, you've got to have teams coming in town. You got to advertise it to the tourist. You got to, how many tourists are coming to town to play softball? Probably the softball leagues, which have, which need hotel motels, and they need fast food restaurants and places, and they only stay 2 nights, Friday, Saturday night. So we looked into this, and we talked about this, and this went on, and there's a lot of information out there about it. It does not work for a TDC-funded sports complex unless you're going to go to regional sports events, and the local people want to be able to get on the fields. They don't want to have to fight big league, big dreams. Gave a proposal. They're on those fields 365 days a year. I don't think that the TDC funding is going to fly. From the advisory council board, I think it's got to be a funding from Walton County, because it is a local constituent citizen sports complex. I just don't even see the point in regurgitating it through the TDC once again.
Mr. Chairman, one of the benefits that I could see of having this is to help to alleviate the crowding on Helen McCall Park. Second thing is that looking at the TDC reserves of $36 million, of which there are some that are earmarked for beach renourishment, and for that there is money that's available there to provide the opportunity to go forward in short order with this. The short of raising property taxes or an MSTU or an MSBU, which I don't know has a lot of support, but which is going to require other action. My offer is to try and move something forward with an opportunity to say we have identified funds that would be available or could be available to make this happen and to do it. If not, I don't see this moving forward anytime in the near future, because I can't see using our ad valorem tax money for it. We're still trying to catch up from the impact of the oil spill, not only the property taxes, the gas taxes, and the sales taxes, and we've got a long way to go. And we certainly have a lot of impact that happened to our public safety and to our road department as a result of that. So to digress away from their continuing imminent needs for the purpose of taking general funds to do it, I'm trying to make an offer of an opportunity for consideration of where we could go to get the money, where we could provide some relief to Helen McCall Park, and at the same time give opportunities for the citizens to have an area to use south of the bay. I can't believe that you'd have 24/7 of tourists.
That's what they want to do. That's what you have to do.
And that's my proposal, and I'd like to get it looked at.
In response to that, I'll remind us that we have spent general funds on the infrastructure at Mossy Head Park. We just spent $1 million on infrastructure for the sheriff's department. Okay. I am not done. Okay, I'm not. I'm not done. Okay. Okay. VP funds went into the general account. Now, what I'm saying is that There is money in the landfill account. There's money in the BP account. There is money right now that we could purchase this land with cash. With cash. Now, it just depends on what our priorities are. Are our priorities to keep denying the folks south of the bay the infrastructure that they need, that's desperately needed? As the sheriff said, we're in dire straits. You look at 30, we are in dire straits. We are in desperate need, just like they said. This is not going to go away. This is not going to pass the TDC Advisory Board for using funds for this. I guarantee you this. I know the people down there, and I know it's not going to happen. Walton County is going to have to cough up some general funds or some solid waste funds or some BP settlement funds to do this. And I guarantee you that is what needs to be done.
Okay, Commissioner.
First, I'd like to correct the fact that none of the Mossy Head money came from the general fund. It came from the landfill fund. Secondly, what I'm trying to recognize is the fact that when the oil spill hit and the property values declined, and it was declined principally below the bay, so the benefit from the ad valorem tax relief occurred there. The biggest components of the funding that the property taxes went to pay for, the hits came to the Sheriff's Department, the EMS with regards to their ambulances, and the biggest hits were taken by Public Works in order to help us balance the budget. So I think to say take the BP settlement funds and use it for that, I think we should be trying to bring our public safety, our public health, and our road issues back to a level of where they had previously been sustained at in order to keep going forward with the county.
Well,
and don't get me wrong, if the TDC council says, we don't want to go there, I'm trying to find a way to move forward promptly with doing something for this area to address their needs, but not at the expense of those other areas.
Well, and I'm telling you that, there's no way other to move forward with this. You can't keep sloughing off everything to the TDC. You just cannot do it. The county's going to have to buck up and realize that with $11 billion worth of real estate south of the bay, you're going to have to put some investment money down there. And when you say that, the BP oil spill got everybody tax relief, well, I don't think people looked at it like that. Like, oh, good, there's an oil spill. My taxes have been decreased. Mine maybe went down $600. Now they've gone back up $600 this year. I'm homesteaded. The economy's back. We've got Mossy Head that's going to produce $1 million in gas tax. We've got the third highest gas tax in the state because of the tourism. We've got BP settlement money. We've got solid waste money. We've got, I'm sorry, but we're at the point now where I've seen all these numbers, and it's time to act. And you've got, whether it's use some money out of each account. I'm not saying use all the BP money for the sports field, but use some money, buy the fields, and get that going. That's how you get that thing going.
Okay,
Mr. Chairman, I don't believe anybody said, oh boy, the oil spills here and my property value is going down to save me money. I don't believe but that's where.
All right, Ms. Meadows, I understand that, Ms. Meadows. Allow him, he's got the floor, allow him to finish his comments.
That's what he said.
I know what he said, but allow him to finish, please.
What I'm trying to find is a mechanism to move this thing forward. And I've articulated previously the fact that where the budgetary hits came from in order to balance the budget in the years of the oil spill and the years immediately succeeding it. And I don't think that to deny them some of the relief that they need to help get back on the track. Last board meeting, we allowed the sheriff to get back on track, and it was sorely needed. If you just take a look at our repair facility out there, you see the ambulances out there half the time. So I'm just saying, the administrative portion of the BP settlement, I do not believe should be used for recreation. I think that it's an overstatement to say that this thing is going to be used 24/7 solely by tourists. I mean, we've got 2 tourist seasons. We've got the spring break, and I know where the spring breakers go, and the other is the summer months. But be that as it may, the effort here is to try and move it forward with an identified funding source that can be used both by tourists and also by the residents.
Okay, thank you. Okay, I see a couple of hands out there. I don't know who got up first. Ms. Harris? Okay, Mr. Hudson? Come forward and state your name for the record again.
And I have nothing personal against Commissioner Enfield. We just disagree.
Reasonable people.
Thanks for providing all that entertainment.
Yeah.
For the record, my name is Bob Hudson. I'm the Executive Director of the Walton County Taxpayers Association. I'd like to remind this commission that several years ago, when you needed a sports complex in the city of Freeport and we needed to expand Helen McCall Park, how did we do it? Do we do it with TDC dollars? No. How did we do it?
We gave Freeport $5 million.
I think we went to the bank and borrowed the money to do it. I think the commission voted to do that 100%. I'm not a bed tax collector, but I do pay bed taxes. I rent places for my family to come here and things of that nature. I will tell you that the Walton County Taxpayers Association polled its membership, about 3,000 people, and they were totally against using TDC funds to pay for a sports complex. The basic reason was the director of the TDC stood up and said, if I use dollars, TDC dollars, to build a sports complex, I'm going to do what? I'm going to fill it up. And I think what the citizens that live in the southern part of the county have said is, we need some ball fields. We need something for our kids to play on when they want to play. We don't want to play when competition from outside. It's not our desire to bring in people in that respect. So even though I admire Commissioner Enfield's desire to move the process forward, I think you can vote to move the process forward today without the use of TDC funds. I stand before you a lot of times and talk about taxes and things of that nature. I don't know where anybody in this room thinks taxes went down because of the BP oil spill, but I'll show you my tax bill since that time, and it has not gone down a single year. Gone up every year. Is that all because of the BCC? No. BCC has pretty been stabilized. The only thing, I'm homesteaded, just like everybody that lives here permanently most likely are. And we get in what's called the recapture rate. We get a 3% or whatever the cost of living adjustment is, increase in our bill, no matter what the value of my home is. So I do think there are options that are out there, Commissioner Enfield. I truly do, and I appreciate you trying to move this process forward. I just think that the people who collect and pay this bed tax want to see that those dollars used for other purposes, and I would encourage the board to look favorably on some type of funding mechanism. Let's go to the bank. We got plenty of reserve. We got plenty of borrowing capability. I think Mr. Alford will back me up on that. Pay for it over a long period of time. You don't back him up? You don't have borrowing capacity? That's not what your audit says. Thank you.
Mr. Hudson, you have a interesting thing. There are a number of other potential funding mechanisms.
Yes, sir.
And there's even some opportunity, perhaps a couple of years down the road, when the bridge is paid off, to see if there's other opportunities that a referendum might support for 30A, Scenic Gulf Drive, sports complexes, and road paving. However, it's a little early to do that because the bridge is not paid off. But there's a number of opportunities down the road. This was an attempt to move something forward today, and I appreciate your comments. So I just want to thank you.
Commissioner Enfield, I agree with you 100%. There are opportunities, there are options that are out there. I think we've made a $4.5 million payment on our bridge loan the other day. If I'm calculating correctly, that's going to be about 5 more years unless we find some other way of doing that. But I would remind you that ball fields in the north are not restricted just to northern participants. Ball fields in the south are not just restricted to people who live down there. Roads in the north are not restricted just to people that live in the north to drive on them, and I don't think athletic facilities for youth should be borne by any one particular area. But I know the need is great, and I know the interest in getting it done is there. You don't have to go to the bank and borrow the money to build the ball fields and all those things if you feel like you want to buy the land. I don't even remember at this point in time what the offer was. But I believe you could acquire a bank loan pretty quickly to just purchase the land and as you go forward. Thank you.
To add to one of your comments here, I believe if you take the current projections on the sales tax collections, this bridge should be, our portion of the bridge should be paid by the end of 2016.
I'm glad to hear it. That
we are too.
I'm not going to pay that tax anymore, or are we just going to shift it? That's fine.
Yeah. Is that it, Mr. Hemphill?
It's in the form of a motion, whether it goes any further or not. It's just an attempt to get it forward, and we just need to decide do we want to go forward.
I'm sorry. Ms. Harris?
So Bagby, is he gone?
First off, I am a bad tax collector, but the TDC, Jim went to a tremendous effort to do a survey. And the survey was sent out by the taxpayers group to everybody. It was sent out to every owner I have at Edgewater, whether they live in California or where they live. It was sent out to everybody south of the bay. And it came back that it was very, very low on anybody's priority list. So now residents in South Walton all got that survey. The South Walton Community Council got the survey. Everybody got it. Y'all need to look at what the people in the South End said. Am I for the ball fields? 1,000 million% for our children only. We've got one in Birmingham. It is rented all the time. We also have our own fields for our kids. Atlanta has that sports park that Larry checked on with the people. It's rented all year long. It's rented for not just balls. It's rented for everything. They do rodeos at it. They do everything at it. It is rented year round, and it makes money. So as long as you want the TDC money to go to it, then what Jim said before was he's going to book it all the time, and the TDC is going to make a lot of money. But you're not fixing the problem for the kids. Till you give these children that live here, and you want all these developments to come and people to move here and live year-round, but you're not giving them anything to do except drug and drink and hang out. That's all you're giving them to do. Give them enough sports fields that they can play ball. Give them somewhere they can play soccer. Give them somewhere they can go, and that the people that live here can be rewarded by y'all instead of punished. Giving you something you really need, but you can't use it is like saying to a child at 16, I bought you a new car and it's going to sit in the driveway, show it to all your friends, but you can't ever drive it. All you can do is look at it. Now, y'all need to realize this is an election year. This is ludicrous to just think the TDC is a pot of gold and we just keep getting the money. Do something for your children. And if the TDC can find a way to help, that's great. But make the commitment to do something for the children that live here. Now, that is absurd. And, Bill, I'm not mad at you, but we said the sunset. We said that half-cent tax would sunset for the TDC for Southwest Airlines. Now everybody's coming to me talking about, well, you know, we might not sunset that tax. Then you talk about, well, the bridge tax is going to sunset. Has anybody asked Jim? I'd like to ask Jim to come up here, because I got an email from him. I sent to him on Sunday morning asking what his opinion was about this. But maybe y'all need to have Jim up here and let him really tell you what his opinion is, and I'm going to be shocked if it's take the TDC money, because that's not quite what he and I have talked about. But I'm just telling y'all, do something for the people that live here. Stop worrying about the tourists. Stop worrying about raping the tourists by getting more half cents and more half cents. Because if you don't sunset the one you promised to, nobody will ever believe you again when you say a tax is going to sunset.
Thank you. Yeah, anything else?
Somebody raising a hand back there.
Oh, my,
Somebody's
okay.
in the way back.
Whoever it is. Identify yourself for the record when you get to the podium.
Andrew Campanella, thank you very much. I wanted to speak in support of what Commissioner Meadows said in terms of not using these funds for the building of the fields and instead find another way to support Parks and Recreation in South Walton and throughout the county. If we're going to use tourism money, we should figure out if we're going to be investing that money in what our ideal demographic of a tourist should be in Walton County. And do we want to bring in sports teams at the rate of what building these fields would bring those teams into the county? I think that's a question that we need to ask. In terms of extending the bridge tax, which is really the reason that I wanted to get up when I heard about that, I think that everyone I've talked to in this county wants that bridge to be finished, and then they want that tax to be finished off. Thank you.
Mr. Chairman, and I wasn't suggesting that we extend the bridge tax. It was just in discussing with Mr. Hudson that there are multiple things to look at.
Well, yeah. Well, it's always going to come down to the funding source. Now, I understand the TDC funds. You really got to earmark tourists coming in here by using that. But then again, our local people down there, and maybe even Freeport that want to use that facility down there, a new facility, wants to have access to it. And when you start putting these things together, we ain't talking about $250,000 to build a ballpark. We're talking probably $12 to $15 million to do it. So we got to come up with a funding source. And some of the emails and conversations I've had, we want it, but I don't want you to raise my taxes. I don't want to put an MSBU or TU on me. I don't want any of that, but I want it. Well, if we went out and borrowed the money to begin this process, it's got to be paid back somehow. So we got to look at, well, ad valorem might have to go up, or you're going to have to do this or do that. So we got to, you can't have your cake and eat it too in some regards. I mean, if you want it, I'm willing to go down there and start on it tomorrow if you can get me a funding source that I can use that is not going to satisfy 50% of the people in this room or in the county. I'm sorry, go ahead.
Resource for you. Take $2.5 million out of the solid waste fund, buy the piece of property, pay cash for it.
Okay.
One of the piece of properties is cleared enough to where people could go out there and practice ball probably with laying sod. Now, that's how you get it done. That's what you do. That's how you get it done.
Okay.
If you establish a TIF, then maybe you could pay back some of that with the TIF. But the money is there. You buy the property, and you get it going.
Okay, thank you. Tim?
For the record, my name is Tim Pauls. I just couldn't sit and not say my 2 cents worth. I know the spray field. I know that property, and it would not take a whole lot of work to be able to grade that property and make it usable. I think that one of the most important things that you can consider is where the new school may go. Because it's time for us to coordinate the outdoor recreation facilities that a school needs and what the community needs. And I think there's been some talk about the school being able to purchase something next to that property. And that would be a really good use of our taxpayer funds that we're paying for. Because a lot of times I see school facilities in South Walton that are not being used. There's all kinds of fields. They're not being used. So if we would put some of this together, it would benefit all of us Because South Walton, if you haven't been down there recently, go down there and look at the new subdivisions. I mean, it's growing to beat the band, and they're not all second residences and trophy houses. They're people who are moving there, permanent residents, and have kids.
Thank you.
First thing I think we need to do is to identify the piece of property we're going to purchase. If there's 4 pieces, every piece is going to be different what you're going to put on it. I'm sure. I don't know if they all, what size tracks they are, but we need to know what the property is going to look like and then make the determination where we're going to fund it from.
And Commissioner, we're going through that process right now. We've challenged or tasked our environmental folks in Public Works to do, take a look at all the aspects that would impact the ability to develop those parcels into a usable facility, and we'll have that report for you at the next meeting.
What does the 1% garbage tax bring in per year? What's it bring in per year? Billion?
To cover all the expenses, it brings in about, was it about 14 million?
That's the number I'm thinking is about.
You know, you could levy, might look at levying a quarter of that.
One of the
borrow
things,
the money and levy a quarter against paying the note off.
but remember, we also picked up additional coverage for commercial pickup, which is going to be adding costs this year to the collections. I don't know what the projections are now for what will be available at the end of the year. So before, I'd like to have some numbers crunched before we do that.
I
but
agree
you've got
with you.
additional costs this year we haven't had in the past.
How much is in that fund now? Do you know? What's in the reserves?
I think the solid waste account is between 9 and 11 million.
There is currently 6.6 million of committed but not restricted funds that are there.
Well, and two, you know, I think let's look at see what percentage you think we could come up with to bring that to us to what percentage if we gonna borrow the money to buy the land and do the fields, figure out what that's gonna be.
Sure, and that's part of the assessment we're looking at is, you know, what options are available.
Any other comments? Need any action taken on this?
So May 13th meeting is going to be the presentation by whoever on the top 2 sites.
It'll either be 1 or 2, depending on exactly what we find when we look at our assessments. We'll have a recommendation for you then.
To look at the readiness of the site, the ability to get out there quickly, lay some sod, no wetland permitting, no, you know, all that stuff that you have to do on some of these properties. Take a look at that.
Yes, ma'am.
All right. Commissioner Pridgeon.
Yes. I'd like to request to apply for a historic preservation small grant for the old Darlington School. It's a matching grant, but we've applied for several grants in the past, and grants are pretty competitive now. Funds are very limited, and I'd like to apply for that grant.
What's the amount of the grant?
50,000.
We have to match 50?
No, we don't, but we don't know if we're going to get the grant, so.
Motion to approve.
Second.
Okay, we've got a motion and a second. All in favor say aye. Aye. Motion carries. Commissioners, I just brought this up on my side of the fence, just basically for discussion purposes. There's a lot of logging and operations that are going on, primarily in the north end of the county. There may be some in the south end. And most recently, in the last week, I had an event that took place on one of my roads where the logging company operation was tearing the road to pieces, left it, and subsequently people that lived on that road could not get back home. After some discussion with the logger through Wilmer and my road foreman, and the administrator, a solution came about, and the road has been put back in its original position or condition. What I'm asking is maybe we need to look at coming up with some type of mechanism that puts logging operations or others that bring impact to our roads so they can put them back where they were before. And this one operation last week, he basically told us to go pound salt. That's another one of them things you want to know about. But anyway, and we told him no. That road, yes, it's public road, but it doesn't. Nobody has the right to go out there and tear it up, because my tax dollars has got to go back out there along with everybody in this room. So I just ask maybe board direction to look into seeing what we can come up with. And I'm not asking for going to get a permit or anything like that. I think maybe to the effect that they have to notify the respective road foreman in the area where this operation is taking place, so they can go out there and see what it was pre-operation and post-operation, to take the necessary steps, their necessary steps, to correct whatever issue that may be out there. And in this particular one, it most recently happened. My guys were out there for a week trying to keep that road up whenever it should have been the people that was tearing it up fix it. And I just throw that out for discussion, and maybe if we can get the board's direction to get staff to start looking into that. I talked briefly with Billy McKee this morning, and apparently he has already found some stuff. I'm not going to ask you to come up, Billy. I think we've set that for a future date of how other counties and other states have taken measures to limit the amount of damage that's done to the county roads.
Mr. Chairman, how do we know when there's going to be a logging operation in any particular area?
It normally, now that is a question, but I think if we put it in the form of some type of guidelines or requirements, that if you're going to come in there and log a particular area, and we can get that out to these respective logging companies, and of course some of them come as far away as Bluntstown and elsewhere, but they're normally the same entity that's doing business throughout the Panhandle. But it doesn't take long. At least in my district, you can travel some of the main roads and you can pick it up real quick. You start seeing that semi-traffic coming out. And we've had it where they actually keep coming out of muddy fields, and I got it that high on the road of mud and dirt that people hit, and you know how low cars are today, then knocks the whole front end out from under it. So I'm just saying we just try to get it out there, and we can have our road foremen or county workers, as they see that operation that we may not know about, bring it to the foreman's attention, and let them go out there and make that contact.
And I'd like to echo, last Friday, Mr. Jones and I were looking at some of the damaged areas up in District 3, and while we're out there, a logging truck pulled through a dirt road that's already very iffy in passability and was tearing things up. So it's not just limited to your district.
Yes.
So I'd like to see something, if we can do something that it's comprehensive.
Well, I would like to the board to direct staff to start looking into that and see what they can come up with as a review. And I think Billy McKee back there has got several examples that can be used as a starting point.
Yes, sir. We'd be more than happy to. And quite frankly, from having spent an afternoon out there with a couple of those guys last week, anything you can do that give us some mechanism to say, you know, you can't do this would help, because last week's approach is not one we want to take on a regular basis, quite frankly.
No, I should have been there with a smoker, smoke him off of you. That's another one, too. The smoker. Bee smoker. I've got to one day. All right. I guess, Mr. Pauls, you're next, sir.
For the record, my name is Tim Pauls, and I'm here representing myself and my wife, Alice, and I want to say thank you for allowing me to be on the agenda today and to bring this matter to your attention. Beach Highlands is where I live, and it's a 91 platted lot subdivision with recorded covenants and restrictions dated January 16, 1961. Lot 16A is one of those lots in the covenants, which on page 329, third paragraph, where it says, no business shall be permitted or maintained on any lot or lots except lots 16A, 17, 18, 19, 20, and so on. Delineates which lots can be used for a business purpose. I acquired the property on December 29th of 1997 while the covenants were still in effect. In 1994, Judge Remington wrote an order in response to a lawsuit in Beach Highlands regarding the use of a residential lot for a bed and breakfast within the subdivision, and in that order he clearly states that Beach Highlands designates 79 residential lots and 12 business or commercial lots. In 2001, the covenants and restrictions of Beach Highlands expired. May 14th of 2008, Vardaman Associates wrote and presented the Beach Highland Neighborhood Plan. A copy of that plan, as well as some of these other exhibits, I have provided in my submission. On page 2 of that plan, it says, covenants and restrictions that controlled land development in the subdivision were established in January of 1961. True. Among other development standards, the covenants and restrictions limited development in the subdivision to single-family residential uses. Not true. In the past, the county has allowed properties designated commercial by covenants and or plat, even if those covenants were expired, to be considered for neighborhood commercial. If you look at this neighborhood plan and the goals of the neighborhood plan, which is really not a neighborhood plan, it's one subdivision, not the neighborhood, one subdivision. None of the goals of the Beach Island Neighborhood Plan have been accomplished. There is no functioning neighborhood association. However, the neighborhood plan says that anybody wishing to amend it has to come back through the association. Well, these are the same people that adopted and wrote a plan that was fraudulent to start with. But my question is, now what? My property has lost its right to be able to be considered for neighborhood commercial, which is directly across the street from me in Beach Highlands First Edition. Who am I supposed to go to be able to see this right corrected, the plan amended, or changed? That's the direction that I'm asking the board for. And there are other neighborhood plans that may not have exactly the same problem, but there are similar problems that need to be corrected and amended within the neighborhood plan. And there needs to be, in my opinion, a process that is beyond a quote-unquote neighborhood plan association that may not exist, that will allow for these proposed changes to be heard by the Board of County Commissioners. And I'd be happy to answer any questions.
Okay, Mac.
Thank you, Commissioners. Matt Carpenter for the Planning Department. Mr. Pauls does live within and has property within the Beach Highlands Neighborhood Plan. And for, well, at least 3 of you who were here in April of 2008, you may recall that the Neighborhood Plan Ordinance, which moved the neighborhood plan process from the Comprehensive Plan to the Land Development Code, was a fairly contentious set of public hearings that finally resulted in the language that appears in Chapter 2 in the section entitled Neighborhood Planning. One of the very contentious points of that particular neighborhood planning program ordinance that was widely discussed had to do with how do you modify the plan once the plan has been created. And the very last point that this board essentially ruled on or considered before adopting that ordinance was that the process for amending the plan shall be the same as the process for enacting the plan. And in this particular case, that process is available to Mr. Pauls right now. The Planning Department is prepared to assist him with that, as we have been since he wrote his letter at the beginning of this year. Now, this does not require an existing or the previous neighborhood planning group to decide that, yes, you can come forward with this again. You can start the process over, just like that process. That group started the process. All you have to do is come in and register your group, and it can be a group of one, and then you go through the process of notifying the neighborhood by certified mail, and you ask the question, would you like to consider amending the neighborhood plan for whatever process or points that Mr. Pauls would like to see it amended? Now, those ballots come back, and you actually send out a formal voting ballot to every parcel owner within the neighborhood plan. Those ballots come back, they're tabulated by the clerk of court, and if 20% or more of those ballots respond affirmatively that they wish them to proceed with the process for amending the neighborhood plan, then the very next part of that is to notify them of a community meeting. And it's the same process that was used, and that process is available today. There is no existing group within the Beach Highlands area that must be consulted or that must approve this particular plan. You can start the process again, and it can be a group of one. And if 20% of those lot owners say, yes, let's move forward, then the process will move forward. If 20% or less than 20% want the process to move forward, it will not pass, and it will not be amended. Now, this particular neighborhood plan does what virtually all of the ones that have been adopted under this ordinance does. This is a residential preservation neighborhood, and for the three of y'all that were here when we, back in 2008, one of the biggest concerns was a developer coming in and buying up lots in a residential preservation neighborhood that had an established pattern of residential, asking the BCC to change the land use and to have the opportunity to put up something non-residential in the middle of a neighborhood. But this one does exactly what was intended. It essentially puts a cap on the land use in the neighborhood. And it can be changed, but there's a process to do that, and it's the established neighborhood planning process. And that is available. Now, the case that Mr. Pauls referred to was a case, and I must disclose that by law, I'm not an attorney. I'm a real estate broker and a planner. I'll defer to the our legal counsel for that particular aspect. But the case in 1994 involved neighbors suing other neighbors to enforce the covenants and restrictions that were actually still in place at that time. The reference that Mr. Paul makes from the judge's order that this is primarily residential except for 12 lots, that was true then. But when MARTA extinguished the covenants in 2001, whatever the judge said didn't matter anymore with regard to those 12 previously designated commercial lots, designated not on the plat, but within the covenants and restrictions that have now expired. And the fact that there were 12 lots that were previously allowed to be commercial under the covenants was widely discussed during the Beach Highland neighborhood planning process. So it's no secret that those entitlements went away when state law through MARTA extinguished the covenants. That was the whole reason for the neighborhood planning process. Under state law, there is a process for reestablishing expired covenants. It's a very cumbersome process, and most folks give up, essentially, because by the time the covenants expire, you no longer have a homogeneous neighborhood, and lots of folks want them to go away. And you can't get the number of votes necessary to reestablish them. The neighborhood planning process was our local process to help maintain neighborhoods. And that's what this one is doing. But there is a process to change it, and that is available to anyone that lives or owns property within the neighborhood plan area. Be happy to answer any questions.
Any questions?
Yeah, I do have a question. How did all those pieces on 30A get rezoned, or I'm going to call it rezoned, or land use to commercial in the past couple of years. Wasn't there an old code that said that if you were covenants and restrictions or commercial existing use or on the plat, that we recognized that, and that is that the standard that we use to change, to land use amend all those parcels on 30A?
Yes and no. None of those parcels are within neighborhood plans adopted by this board that are components of the Land Development Code. We do have language in the residential preservation land use category that allows a non-residential use if it's identified on the plat,
right,
and it is not in this case, or if it's allowed in unexpired covenants and restrictions. In this case, the covenants have expired more than 10 years ago. There's a third one in the neighborhood commercial that allows us to change land uses to neighborhood commercial if we've got an established neighborhood commercial use that's been continuous since it was previously allowable under whatever previous code allowed it.
Okay.
But we don't have a process to revive expired covenants. State law provides that.
Exactly. So we've changed those terms to if you have expired covenants, you're done. You're pretty much done.
Yes, ma'am.
Okay, so we changed that since I was here.
Well, I'm not sure if it was ever changed, but that's what the code says.
Okay, because when I was here before, when people came in and argued, well, this covenant has been expired because it was expired in 1950. But, however, we allowed them to go ahead most of the time and change that because we decided that it didn't matter if it was expired or unexpired. We would let them change it to commercial. But my question to you is, and that's what I recall, but my question to you is, wasn't the purpose of the neighborhood plan not to change land uses, but to, as I recall, but to have folks have the option, like as in Inlet Beach, remember when some people wanted to go to higher density and some people didn't, we gave them the option, and so the plan came out where we didn't attack your land use, but rather we allowed you to set in place setbacks and other height restrictions and noise like Grayton Beach. But we never addressed your land use because I thought as a group said these neighborhood plans are not to take away a person's rights and abilities, but rather to allow the neighborhood to not to affect somebody else's property use, but certain things in the neighborhood that they wanted as a group to do, like Grayton Beach.
Yes, ma'am.
Is that the truth?
None of these plans change land use. They preserve the existing land use that exists on the date of adoption. And that's exactly what's happened in this case. Without this neighborhood plan, the expired covenants would provide Mr. Pauls no rights for non-residential use. Now, the only thing he would have available if the neighborhood plan did not exist was the opportunity to apply for a small-scale amendment to change his land use. And when we went through this in 2008, that was exactly the purpose of the neighborhood plan, to make it more difficult for people to come in and either acquire or if they already owned it, to change land uses that would be disruptive to the neighborhood.
Okay. And I agree with that. However, we've got some changing conditions on a road called 30A. You've got 3 million tourist visitors a year. 100,000 of them change hands every week. You don't have any method of four-laning that road. So that road, that condition of that road has changed drastically. Now, I personally would not want to live on that road in a residential house. And we have a lot of people now calling us saying, can you lower the speed limits? Can you put speed bumps? Public Works and I were just out there last week. We got to do something about this speed. We got to do something about this noise. So I realize that we have a neighborhood plan, But I think that the neighborhood plan was never intended to thwart the efforts of people who had houses and businesses on a busy highway to not ever be able to at least apply for a change in use.
That's exactly what all of them do. Unless you go through the neighborhood plan process to change the neighborhood plan to provide that opportunity.
Right.
That's what
Can
everybody,
you
all of
name
these
the
groups
other?
wanted.
Can you name the other neighborhood plans who have places that front on 30A that?
Blue Mountain Beach neighborhood plan.
Okay, and we've got the creamery right there on the corner.
There was an exception made for the creamery that allowed the BCC to do what they wanted to do on that particular lot outside of the neighborhood planning process because we were in the middle of changing that when that plan came through.
And we also have Grayton Beach.
But none of those lots are affected by that. Now, we don't have a neighborhood plan in Grayton Beach. We have some other specific ordinances, but there's no neighborhood plan for Grayton Beach. There's one that has been proposed.
Right.
They're in the process, but that has not come back to the county yet.
Okay, you're right. I forgot about that. You've got one in Inlet Beach.
Now, the Inlet Beach plan is a component of the comprehensive plan. It's somewhat of a different animal. And the experience with the Inlet Beach plan, I think, is what this board caused this board to direct that process be moved to the Land Development Code so it wouldn't be a large-scale amendment.
Well, it appears to me that through these neighborhood plans, the way that we've changed it to the Land Development Code, that we have tied up some knots that I don't think we intended to tie up. And that's folks on busy highways having the ability to address their issues. Now, I can understand if it's in the middle of a neighborhood, yes. But, it seems to me that we've created our own sticky wicket. Because a lot of people don't want to live on 38. The traffic is just too bad. So how do we deal with that?
Well, we have a process for changing specific neighborhood plans, or this board can amend the process for neighborhood plans, or this board can just, I guess with a stroke of a pen, decide to adopt an ordinance that repeals them all. I mean, those are options available.
No, I'm not saying throw the baby out with the bathwater. I'm just saying that changing conditions have created some conditions that I think we might need to address. That's all I'm saying.
Direct staff to undergo an amendment to a neighborhood plan or to take up an amendment to the neighborhood plan and follow the guidelines. It doesn't have to come from the neighborhood the way I've just looked at it just to.
Yeah, I think you're right.
I think you could say, whatever neighborhood plan, we have changing conditions along 38. Why don't you guys look at an amendment to that? And you have to go through that same process.
Right.
Yeah.
Okay.
I mean, right now, other than just amending the ordinance, we have one process to amend a neighborhood plan. And that requires the ballot of interest, and that ballot of interest has to get at least 20% affirmative vote to proceed with amending a neighborhood plan. And the only people under our ordinance that are allowed to vote are those lot owners within that neighborhood plan.
Mr. Pauls, you gave us a map, and it's so small and all that. Which parcel are you talking about?
I have a larger plat, Mr. Chairman, if I can approach.
Come on.
You're able to now see lot 16A, which is here, goes from here to here, over here. So if I can just
mark it, because I think it's right there.
Which one is it?
16A.
Yeah, it's right there.
Yeah, I'm blind as well, so I can't see. Is 16A the big?
This whole piece.
The big lot. It's that big lot. Okay, the big lot. What percentage of that is is unusable?
There's a conservation easement on that property that is approximately an acre. The total property is about 1.6 acres. There is a easement called Starworth Lake Trail that I created. Actually was created through the original purchaser in 1996 to allow for access to the lake. As you know, what everybody wants to know is how do I get to the beach? And the way you get to the beach in this area, if you have that easement, is with a canoe, and you're 5 minutes at the beach.
And so how many acres did you put in a conservation easement on this property?
Approximately 1 acre.
1 acre.
That property is in a conservation easement.
But you've got 0.6 of an acre that's left, basically.
Well, the property is essentially developed. There's a house, an addition, garage. It's a large house, and I doubt that somebody's going to buy it and tear it down, but the chance of being able to use it for something other than just a monster house and rent it and put 25 people in it, of which your ordinance would not stop at this point, could be done. Instead, if you could actually do something else with the house, even as specifically mentioned in the neighborhood plan that it's not allowed a beach and breakfast, bed and breakfast, right? That's what I was looking for. I mean, it seems to me actually it's a higher and better use.
So what's the difference between a bed and breakfast and a house that rents to 25 people?
Breakfast.
You serve breakfast?
Bed and breakfast is considered a neighborhood commercial use under our code.
Bed and breakfast
A house
is.
that rents for 25 people today, we can't do a single thing about under state law.
That doesn't serve breakfast is actually a single-family residential use. Okay. I just want to
Wayne?
clarify that.
Chairman, on a similar note, we do have, I believe we'll have a request also, or from Point Washington Neighborhood Plan, they are also have asked about how do you amend the neighborhood plan. So this one would not be an isolated request.
I think Wayne makes a valid point. If we're going to make some changes to how to amend the plan, let's not make it specific to this instance. Let's look at a comprehensive look of how we address those items and issues that may come before us. And if the way that's set out in the ordinance, which is to go through the same process, is not where the board wants us to be, we'll certainly entertain any thoughts or ideas or work with staff to come back with some recommendation that may make that process easier, particularly when you've got a situation where obviously the intent of this lot was determined in 1961, and because of a time period and extinguishment of the covenants and restrictions is no longer there. So there may be, maybe part of that review may be some mechanism of how to move that intent forward.
Well, and that's why I ask about all the other ones, because I can see this. There's a lot of homes on 30A that, that are now really, you couldn't live there. And I can see people coming in and saying, well, but, so I think it's going to be an issue.
I certainly agree.
Chairman, and from my position, from a professional planning position, this may not be popular with neighborhood plan folks, but anytime you lock it down to where you don't allow any changes to it except for a very rigorous process, to me sometimes that might, because things do change, conditions do change, and there needs to be some ability to recognize those changes and have some flexibility to be able to address those as time goes on.
If I could make one more comment.
Yes, sir.
What you have to realize is it would take 18 votes to be 20%. There aren't that many lots that even had that designation. So you're not going to end up with people voting to allow something that they were supposedly afraid of. They're afraid of what might be commercial. So they want to make sure it all stays like they are, residential, because they don't live on 30A. That's not their problem. So you've made almost an impossible hurdle. Now, when this was going on, the idea was to include Beach Highlands First Edition, and that should have happened. It should have happened. But it didn't, because of the friction within the community, the people that live there. Now, Beach Highlands First Edition has a whole number of lots that are now commercial. That's right across the street on 30A. So, I mean, I don't have a problem going through and being a party of one. I don't have a problem. I can do that. But I think that there ought to be a method to be able to address this, because this should have never been adopted as a neighborhood plan, because it isn't. It's a Beach Highlands plan. It's not a neighborhood plan.
Okay. Mac?
The ordinance does allow the neighborhood to be defined by the neighborhood planning group. So under the ordinance, yes, this is a defined neighborhood.
All right, what's the board's wishes?
We'd be happy to work with the board about amending the ordinance. I would definitely recommend we have public workshops on this.
Yes, sir, agreed.
And in that process, I certainly wouldn't discount Commissioner Pauls and his expertise, for lack of a better term, in this area. He's demonstrated over a number of years his ability to show a clear path through some of these things. So I think in that process we should welcome his input.
Okay. You gonna work on that then? Okay.
What does Point Washington want to change and amend in their plan?
Point Washington has had a group of architecture students from Notre Dame working on a pattern book, essentially, that lays out particular building types and placements throughout Point Washington. It is something that we're trying to determine the best method to bring that forward. It can be incorporated into a neighborhood plan. They do have a neighborhood plan. They are very familiar with that process. And they've got a fairly homogeneous group as far as being in favor of a neighborhood plan. But that we're working with them to decide exactly how to bring that forward, given that they don't own all the land.
And also, another part of their plan that they want to see addressed is strengthening the tree protection. We've had some issues out there with some clearing and things of that nature, and the tree protection they feel like needs to be strengthened and much better defined.
Okay. Very well. I think we got it figured out. Thank you, Mr. Pauls. All right. Is there any additional public comments? You will state your name for the record and hold your comments to 5 minutes, please.
I think I'll get in 3 minutes.
Oh,
today.
my goodness. Okay.
My name is Mary Nielsen, and I just wanted to bring a couple things to you. Haven't been here in a while. I had the pleasure of vacationing at St. Pete Beach, Pass a Grill, and Longboat Key recently as a tourist. Had never been there before. And what jumped out at me was very interesting. I didn't see furniture in the street in front of shops. I didn't see everything, you name it, whatever it is, all up and down the roads. Longboat Key gives you a beautiful, manicured, landscaped right-of-way on both sides that obviously the inhabitants of both condos, individual homes, huge complexes all agree in some fashion must be their tone that they want to present to the public. It is very, very aesthetically pleasing. And I didn't see all this junk. Now, this little Pass a Grill place, which I don't even know how to spell it, but it's up there on St. Pete Beach somewhere. And it's an old-timey type place with rental houses as you're driving down on one side, and then a 2-lane highway. There's no room to make it bigger unless you were to do eminent domain and bulldoze all these places. There were houses, there were VRBOs, there were restaurants, all kinds of things. And then the 2-lane road, and on the side of the 2-lane road there was one individual set of parking on each side of the 2 lanes. So there's 2 lanes with the line down the middle, and then there's parallel parking on one side, and then there's the angular slots on the other side. And then you're immediately on the sidewalk and going to the dunes and walking down a little path to the beach. Nothing fancy, old-timey. And the parking was interesting in this little Pass a Grill area. They have a very explicit parking situation. So if you've got a VRBO home over here that's sitting right almost on the edge of the the land, okay, in the right-of-way. Their cars are not all clogging up the county's right-of-way or anything, and neither are the restaurants, because guess what? You pay for your parking there, and it's very unique. Each parking space has a letter and then a number, and they're painted so that even when you pull in at the angle or you pull in parallel, your vehicle does not cover this designated slot number. When you exit your vehicle, you walk across the street to go to the beach, and when you do, there is a there's like a little section, and each section has a kiosk. And you go up to the kiosk and you punch in the letter for your slot, and you punch in the number, and then you put your money in for the desired amount of time you're wishing to stay in that slot. Okay, now don't ask me how they computerized it or the guts of it. And I didn't see a lot of policemen, didn't see a lot of code enforcement, didn't see any of those people. But people went up and put their money in the slot, and we went to the beach and took some pictures and walked around, looked at things, and came back. But if you have VRBOs, you have bars, you have grills, if they don't provide their parking, you pay. We all pay to go and eat there. We go to pay and shop. We go to stay. We go to the beach. You pay for it. It was very organized. There was not a lot of commotion. Now, I wasn't there Memorial Day or July 4th. It might be a different story. And Longboat Key has a very, very high-end real estate market, extremely high-end. And they do not have all this junk out front on the main drag. And they've kept it very nice, and their cost, their real estate is really up there. You think we're up there, we're nowhere near up there. And their stores are unique and fun. Now, the second item is, when I came home, I noticed coming down the bridge that on the right at Chat Holly and 331, your land that you own there, unless you've sold it, appears to have been laid out as more explicit parking.
I've seen it.
And I wondered if you have a parking lease and if you're receiving money for that being used as a parking lot by a business across the way or not. It appears that the owner's land is being used as a parking lot, and it also appears that some of your land is now being used as a parking lot. And there's a sign up there hanging in the trees and new lighting out in the trees. And whether the lighting's in your trees or on their trees, I don't know. But there's now wooden barriers designing the parking lot out there. And I think that the real issue for us, the taxpayers, and for you, is if you are engaging in leasing that land, we should get some money for it, and we should worry about liability if somebody trips on the tree roots and breaks an ankle after they've had a few drinks, if drinks are being served there.
Okay.
That's it.
Thank you, ma'am. Yeah, please look into that. Is there any other public comments? Seeing none, I'll entertain a motion to adjourn.
So moved.
Don't get a second down there.
Second.
Second. Oh.